पहला में सर द पहला
डिटेलिंग दिया था यार
बैकग्राउंड
या पड़ गया तो
बोलेंगे क्या तैयार
तैयार नहीं
पढ़ के
पड़ गए
जो
हाँ
जल्दी हम लिखवा देते हैं
बड़ी भारी
Again, I have mentioned that this it cannot be discussed.
May I have your leave to mention that one writ matter which was pertaining to
One
a
of the
writ application, my lord. It was in pertaining to challenging the condition of an advertisement for appointment of independent engineer.
appointment of
Independent engineers. It holds the relevant rules, my lord. It was ongoing before Honorable Justice Sanjeev Prakash Sharma, and it was, my lord, listed on board on 18/4/2023.
single bench.
No, it was earlier before division bench, then it was before the learned single bench because of the change in roster. And now because of the transfer, my lord, it is now nowhere sure to be listed, my lord.
And
We have made a mention before the registrar also, my lord.
before the Chief Justice.
Very good. Because my lord is the motion bench, therefore I was mentioned. I'll mention it before the...
Because there is a confusion, single, division.
No, because at that point of time, the roster...
Correct. Let the
Interim
matter
order has been passed by the division bench.
mentioned before Chief Justice.
My lords.
May I take your lordship minutes to mention one case from the list, my lord?
Wait, sir. Any adjournment between serial number 3 to 5?
Serial number 22 onwards.
Well, 15, my lord. The file has
Wait. Any adjournment between serial number 22 to 27?
16,000.
Only 22 onwards. Any adjournment between
Old matter will not be adjourned. Serial number 22 onwards.
actually, your lordship, the sitting of the office, my lord. The file has been misplaced, my lord.
We will examine the file and we'll pass orders.
My lord.
Any adjournment between serial number 28 to 39?
Lord, 30 will not withdrawal will not.
30 withdrawal. Yes.
30.
35, my lord, after a week.
35?
After a week.
Next week.
Any adjournment between serial number 40 to 42?
41 my lords, only passover.
Well,
41 my lords, only passover.
sorry, 2016 matter.
My lords.
Under the heading for judgment, serial number 1 versus BK Enterprises versus the State of Bihar and others for the petitioner Sri Shirin Sar.
I'm reading the operative portion. In our opinion, no illegality or irregularity has been committed by respondents in passing the impugned order, rescinding the contract, and the reasons assigned for the same are well justified, which do not require interference by this court. All the writ petitions stand dismissed, pending applications stand disposed of.
Serial number 2, Mrs. Malti Infrastructure Private Limited versus the State of Bihar and others for the prisoners, Ms. Usha Kumari.
Again, the operative part, no illegality or irregularity has been committed by the respondents in passing the impugned order cancelling tender, and the reasons for the same are well justified, which do not require interference by this court. The writ petition stand dismissed, pending application stand disposed of.
Under the heading to be mentioned, serial number 3, Ashwani Kumar versus the State of Bihar for the prisoners, Ms. Sanju Kumari.
This contempt arises out of non-compliance of the order of the Honorable Division Bench in LPA. Which your lordships have passed on the last occasion order.
What is that you are filing?
My lords, an IE has been filed praying for exemption of personal appearance, my lord,
And extension.
today.
An extension.
My lords, in this case, the state
How
has,
can you file it today?
not today, it has been filed yesterday,
Day before yesterday.
day before yesterday. Hard copy is being given here, my lord. Soft copy has been filed.
All right. Okay.
He is out of Bihar, attending his seriously ailing mother.
One of the two. The two persons were asked. The departmental secretary and the director.
Director is present. You need not worry about that.
No, I am not worried. I am only pointing out. That was order.
Have you gone through this?
My lords, yesterday in the late hours, a copy has been given.
We'll adjourn the matter.
Okay.
I yet for dispensation of personal appearance of a first respondent is filed. The same is taken on record. For the reasons stated in the application and affidavit, the IA stands allowed to perusal of the pleadings in the IA. In para 4, it is stated that against LPA order dated 28/2/2023, the order of dated 28/2/2023 in LPA number so special leave petition is stated to have been filed and it is numbered as C within bracket capital C 997 of 2023 and it is being listed on 8/5/2023. Therefore, release this matter.
Next week in
15th of May. IA stands disposed.
The exemption is only for today.
Huh?
Exemption of personal appearance of the person.
Yes. Only for today. Exemption of personal appearance only for today.
Yes, my lord. In case any order is passed by the ethics court.
But still, you can't have exemption. You can come and apprise this court. Supreme Court has stayed. Then we will know what order is required to be passed.
Director is present today.
Second respondent, director, so and so is present. Give his name. Give it in a slip, sir.
Serial number 4, Sona Income Private Limited versus the State of Bihar for the prisoners, Sri Ashif Giri.
My lord, I pray for next time, my lord. My lord, on the last day directed to file counter affidavit.
I filed an IA only for the purpose that not the for the upcoming tenders, not the last date is 8th and 9th accordingly. So as an interim relief, not only to allow me to file that tender, And I have also stated that in a similar cases where the impugned order.
You have filed counter.
They have not filed.
I have not received any instruction, my lord.
So
Just take down. Respondents have not filed their counter. For filing counter affidavit, release this matter after 2 weeks. In the meanwhile, petitioner will be permitted to participate in any of the tender subject to result of the
obliged.
Single number 5, Papa Debraha Enterprises versus the State of Bihar for the petitioner Sri Prabhat Ranjan.
Was an ex-party order imposing cost of rupees 10 lakhs by an incompetent authority. Annexure 4, page 23. This is a works contract matter, lordship. Page 27, lordships.
What is meant by construction of plug and play?
Yes, actually, lordship, it was in the industrial area. They are manufacturing fabricating this manufacturing units by fabrication. Yes, and thereafter, lordships.
There is notice formalities.
May I be allowed to file it? Yes.
No, sir. See page number 27. Is it counter affidavit is required?
And the second issue is covered by my lord, that competent authority. Even that, the executive engineer has
passed the order.
Executive engineer, the competent authority is not
in chief.
Yes. No, my lords. In this case, my lords, it is the managing director. Under clause 2, it is the managing director. It has been defined here.
No, the annexure 4 is passed by executive engineer.
Annexure 4 is passed by executive engineer.
Instead of managing director. Yes.
And the second issue is one more decision is under challenge. That is, my lords, annexure 6, page 31, clause 14 order. That has been issued by the executive engineer, and which should have been issued by the competent authority, which my lords have been pleased to decide that he is not the competent authority.
Annexure 6 is it?
Yes.
What is this?
Clause 14 for closing the agreement. Clause 14 of the SBD by which they cancel the agreement.
This is also by incompetent.
Yeah, this is also by incompetent.
Executive engineer.
Yes, sir.
Let him file affidavit. The executive engineer, he is a party?
Yes, sir, he is a party.
Executive engineer, MD?
MD is also a party. Both should be given.
Number 3, managing director, hereby directed to file counter affidavit as to whether the executive engineer is empowered to pass impugned order at annexure 4
and 6.
So far as what is this 10 lakh 63,000?
Liquidity damages clause. Liquidity damages clause.
Damages a sum of rupees 10 lakh 63,208 and further
notice under clause 14 of the SBD.
Notice under clause 14
on the SBD for
clause 14 of
for cancellation of liquidity. Yes. For cancellation of
contract. Sublime counsel for the petitioner submitted that the present matter is covered by earlier decision of this court passed in seal of judges 41 of 2020 dated 21/4. While filing counter affidavit, the concerned managing director is hereby directed to take note of our earlier decision.
In the meantime, they have not taken any coercive action. Clause 14 and delegate recovery.
Matter after 2 weeks. 2 weeks sufficient? 2 weeks. In the meanwhile, concerned respondents are hereby prevented in taking any coercive steps against the petitioner. So far as the present matter is concerned.
There's a heading for orders on office note serial number 6, Soni Kumari versus Mantu Kumar for the appearance fee with Vijay Kumar Vista.
For compliance of office objection, release this matter after 2 weeks.
Much of it.
Serial number 7, Raju Saab versus Rinku Devi for the appeal Sri Vijay Pandey.
And at least solve it.
Why is it required? This is not required. And wait for his particular. It says service of notice held sufficient. Office has recorded service of notice on sole respondent was received by her sister named Sabita Kumari. Therefore, service of notice respondent held sufficient in order to give an opportunity, none appeals for their sole respondent release matter after 2 weeks for appearance of a second sole respondent or through her counsel, his counsel.
Under the heading for admission, serial number 8, Mrs. Prabhat Construction Company versus the State of Bihar for the petitioner Sri Alok Kumar.
This is an old case which has been listed suddenly. We need to seek instruction from the client about the status of the performance guarantee. It's a case of termination of contract, my lord. And there is no provision of arbitration, my lord. Rather, it is barred, my lord. So, my lord, so far as the status of performance guarantee, and there was a resolution mechanism, my lord, but that has not been constituted also.
That is not the subject matter.
Sorry?
Is it a subject matter of security deposit?
Your lordship, termination, consequent upon termination, they have encashed the.
Correct. You are not questioned that.
Your lordship, our prayer, if your lordship will see, the quashing of the impugned order, and then, my lords, violation of natural justice.
If we set aside
Lordships.
dated 26/12/2014, then arises.
Your lordship, your lordship, and paragraph 5, my lord, in the prayer portion is my prayer with regard to that, my lord.
Correct, sir. The second prayer, the subsequent prayer is depending upon the first prayer.
Your lordships.
If you succeed in first prayer.
Your lordship. My lord. Therefore, I am seeking, my lord, that a week.
There is a question of seeking information.
Lord, because, my lord, now it is more.
The petitioner seeks time, release this matter next week. Make clear that no further time would be granted for the reasons that matter is of the year 2015.
Oblige.
Completely latches on the part of the petitioner, my lord, who has not fully done.
Sir, your argument on the next date.
Serial number 9, the Bharat Construction Company versus the State of Bihar.
May I permit it to withdraw this?
Done.
Serial number 10, AEMS Services Private Limited versus the Union of India for the petitioner Sri Mani Sakai.
Not compiled. Serial number 7. Additional petitioner is hereby directed to comply the office objections.
My lord, just 6 at page 167 is under challenge by which man?
At the very outset, your lordship may give me adjourn it 4 weeks. I have received the statement of fact. I can file my counter.
No counter, nothing.
My Lord, Annexure 6 at page 167 is under challenge, by which they have terminated retrospective dates, my Lord. And my Lord,
Terminated?
retrospective dates, my Lord. Termination order is 8/7/2016. They have terminated with effect for 31st May 2015, my Lord. Retrospective dates, my Lord.
Prospective.
Yes, my Lord. And my
Declare it as prospective.
no, well, without notice, without discussion, my Lord. Exact similar case has been disposed of, my Lord. My Lord, can you see this?
How do you say it is without notice?
My Lord, in this termination or there is no discussion, my Lord, about the notice, any...
Where have you pleaded in your petition?
My Lord, prima facie this appears, my Lord.
No, where have you pleaded? It is without notice and all.
I had said, my Lord, that the my Lord, can you see the Annexure 6, my Lord? Two notices were given 7 days and 48. I have replied, my Lord, as one, that is Annexure 7, 168, my Lord. There is no discussion in the termination order, my Lord. Kindly. Kindly see page 168, my Lord, Annexure 7, my Lord. Exact similar matter has been, my Lord, considered and disposed of by your Lordship, my Lord.
Yes, Mr. Respondent, do you have page 167?
Yes.
Your Lordship,
Wait, sir.
Your Lordship, my humble prayer will be what I have prayed it earlier, Lordship. And secondly,
No, if you are praying, we are going to impose cost.
then Your Lordship, there is a clause 47 for arbitration. As Your Lordship have.
But correct, the arbitration, such clause can be ignored by this court under Article 226.
Definitely.
In the event of non-servicing notice and all.
That's why I'm saying, Your Lordship. That's
Set aside and remand the matter.
No, Lordship, I'll just let me, because I have the statement of fact with me, Your Lordship, that Annexure 7 which my friend is placing, though as has been pointed out by Your Lordship, there's no...
Not page, Annexure 7, it is Annexure 6, sir.
Okay, no oblige, Your Lordship. I'll just answer that. What answer I have received for para, Annexure 6 is to para, if I'm correct, is to para 13, Your Lordship.
No, sir, page 167.
Yes, Your Lordship.
The termination of contract. On completion of, terminated with effect from the date of completion of contract, that is 31/5/2015.
May I just read what statement of fact I have received in the to the reply to the para 13 where the Annexure 6 is there in Your Lordships. Denied and submitted letter of acceptance was issued on 11/7/2012. As per the acceptance, the original date of completion was 10/7/2013, and petitioner had to contact railway official within 15 days of the date of acceptance to start the work, but he failed. Due to urgency of the work, petitioner was requested and given 7 days notice with a letter number 2 and 3. That must be, we are supposed to be annexing it to gear up the man and machinery to start and complete the work. After lapse of 3 months, the petitioner contacted railway with waterlogging problem at site. That is Annexure 4 will be annexed. Then he was instructed to start the work at the location where there was no waterlogging. Again, Annexure 5 we are annexing. Again, the petitioner given 7 days notice with a letter number such and such.
7-day notice for what?
To gear up the man and machinery to complete the work.
Correct, but it is not for termination.
Yes,
They are saying that with notice of termination.
Let me complete, Your Lordship. I'll just bear with me for a few minutes, Your Lordship. complete the work. First payment of rupees 7,75,870 was made to the petitioner with a such and such on 25/3/2013. Due to the show progress of the work, we were requested with a letter dated such and such and dated 16/5/2003 and 15/5/2003 to gear up man and machinery and to furnish bar chart for completion of work. Again, 7 days notice with a letter number such and such 2/7/2013 was given to gear up man and machinery to complete the work. Second payment of rupees 14 lakhs 565 rupees was made to the petitioner with a on 13/9/2013. First time extension of date of completion from 11/7/2013, that's the original date, Your Lordship, to 13/6/2014 under clause 17A(2) of GCC was granted for giving opportunity to petitioner to complete the work with a letter number such and such of 13/1/2014. Third payment of 25,79,587 was made to the petitioner on 13/9/2013. Since work was not in progress as cited, the petitioner was again requested with a letter number of 19/5/2014 and 31/5/2014 to start work, but he was not turned up. Then again 7-day notice was given to petitioner with a letter number such and such of 16/6/2014 to gear up man and machinery to complete the work. As per report dated 9/7/2014, the petitioner had started the work on 26/6/2014 but failed to complete the work within extended time of completion of 13/6/2014. Second time extension of date of completion from 1/7/2014 to 31/5/2015 under clause 7B of the GCC was granted for opportunity to petitioner to complete the work with a letter number 17/3/2015. Since the petitioner was not turned up to start the work, he was again requested with a letter number such and such to start the work, that is 10/4/2015 to start the work, but he failed to do so. Then 7 days notice was given to the petitioner with a letter number such and such dated 15/5/2015 to start the work. As per the report of such and such dated 25/5/2015, the petitioner was not turned up to start the work. Then 48 hours notice were issued to the petitioner with a letter number such and such to 26/5/2015 to start work, but the petitioner failed to give report on 29/5/2015. That petitioner was not turned up to complete the work. Thereafter, a contract was terminated with giving details reason with a letter number dated 8/7/2015 as per clause of the GCC. Thus, termination of contract is due to totally failure of petitioner despite giving ample opportunity to complete the work.
There is the specific notice of termination.
Yes, Your Lordship, I'll just place it. What we are saying, though
You may say 100 things. We are simply asking you where is the specific notice.
That's why I'm saying that I'm just saying whether that document is on the record or not. If they.
But if you are asking time, we are going to impose cost.
No, I'm not doing that. I'm saying whether the letter of contracted termination of 8/7/2015 is on the record or not. That says there was a video letter as per the clause of GCC.
That's all. Now you have an option. If you want time.
No, I want Your Lordship may refer it to arbitration.
No, why? We'll simply set aside and remand the matter.
Your Lordship, may I place the annexes 6, Your Lordships?
6, sir.
Your Lordship.
We'll extract the entire 6 order in our order.
Yes, let me place.
We are going to extract the whole.
Yes, I'm obliged, Your Lordship. I'm obliged. I'm not. Let me place it. This is letter which Your Lordship are going to watch. Let me place it. It is intimated that validity of a CA has already been expired since long, 13/5/2015, but neither you have submitted application for extension. This is for the third extension, sir. Your Lordship, which we want.
I don't know why you are repeating the same thing.
Your Lordship, if the Lordships are going to watch it, then let me, I may be permitted to place it, Your Lordships.
Place what?
This annexure, Your Lordships.
This annexure is already there. Why you want to produce once again?
No. Your Lordships are saying that without giving any notice, but
assuming that it is notice is given. for argument's sake, assuming that notice is given, where is the reference in Annexure 6 that on so and so date we have given him notice for termination, he had submitted his reply is hereby rejected. Where is that?
If the lordships are going to quash this termination letter, on that the notices issued to him and not mentioned in that letter, then either I'll seek an.
Do whatever you want. We'll set aside simply saying that perusal of the records, it is evident that no notice has been issued, and reply, assuming that notice is issued and reply has been filed, the same is not reflected in the order.
What has fallen earlier from your lordships, that the notices are not mentioned in this annexure, maybe.
No, we are saying or.
Because there is an arbitration clause as clause 47 of the GCC, and that is there on the record.
Matter is of the year 2015. Respondents have failed to file their counter affidavit even after lapse of 8 years. Next part. In the instant petition, petitioner has paid for the following relief. So the petitioner contract has been terminated with the retrospective date, that is with effect from 31/5/2015 on 8/7/2015 by Annexure 6 to the Annexure 6 dated 8/7/2015 reads as under. Perusal of the aforementioned document relating to termination of contract with effect from 31/5/2015, it is evident that there is no reference of notice of termination and reply of the petitioner, in the event of issuing such specific notice and reply received by the concerned authority, namely Deputy Chief Engineer, author of Annexure 6, 8/7/2015. On this short ground, the petitioner has made out a case accordingly. Annexure A6 dated 8/7/2015 stands set aside, writ petition allowed, reserving liberty to the concerned respondent to proceed in accordance with law. Of the Deputy Chief Engineer is hereby directed to take note of Apex Court decisions issued from time to time, namely UMC so and so, isolator.
Serial number 11, Zahid Hussain versus the State of Bihar for the prisoner Bunyadi.
The petitioner died, Your Lordship, so I want to withdraw this case.
Done.
Serial number 12, Amit Kumar versus the State of Bihar for the prisoner Manish Sahai.
Madam, may I permitted to?
Done.
Serial number 13,
Give a list. How many matters of which you are asking? They are, for the last few days, they are consisting matters. Because they are bringing previous matters.
serial number 13, Sanjay Kumar versus the State of Bihar others for the prisoner Sri Ravindra Pasin.
My Lord, we many attend this matter for 2 weeks. I'm appearing for state, my Lord.
Adjournment refused.
They have to complete a unique period of 1 month.
None appears for the petitioner. In the instant petition, petitioner has prayed for the following relief. Reading of the prayer, it is evident that the petitioner has approached this court prematurely. In other words, is the defense relating to the extension of time or consequential orders like terminating the contract or blacklisting are yet to take place as on the date of filing of the present petition. Accordingly, the petition stand dismissed as premature.
Serial number 14, Harish Kumar versus the state of Bihar for the traditional state in India.
Dear Lord, sir, I may mention the law. Serial number 132 listed and
other similar matters are
common other challenge law.
Other similar matters are before your lordships, but in the weekly list or consolidated list. So if all are tagged together on Monday, we can.
No, whatever the order passed in this will be
common
order to the other matters.
Common order has been challenged, my lord, in all the cases. Serial number 132 is listed with your lordship in weekly cause list. Serial number 144 is also listed with your lordship in cause list, weekly cause list at serial number 144. And on all the cases, common order has been challenged, and in all cases have been filed by me.
All right, argue this matter. We'll decide this.
Maybe, my lords, this application is for quashing the annexure. My lords, what happens in the supplies made to jails? Supplies of items which are made to the jails. Vegetables, fruits, everything. For that, my lords, the tender is invited and there is a district level committee which decides the matter. If there is any interference that the IG at the headquarter level can do, that is period is 30 days. He didn't interfere, therefore the supplies were made. Now after a long time, the Central Purchase Committee issues this impugn order, Annexure 4, that what was there, and it issues a centralized rate. My lords, that cannot, my lords, Annexure 4 is the impugn order, and which in earlier rate applications, similar order has been passed, and that has also been brought on record. If your lordship will kindly see that only, that will make everything clear.
Where is Annexure 4?
Annexure 4, your lordship will find at page 28.
What is the alteration?
Alteration, my lords, at the central level, he said.
Take page 29 and apprise this court. What was the earlier price of a few articles and how it has been modified? Take page 29.
Take 20, yes. Annexure 2 is the Annexure 2 at page 24, my lords. That is the earlier rate.
So there is no comparison. On page 29, 2011-12 is written. On next column number 3 or 4, it is 2012 and 13.
That is what I am saying, my lords. In this very at page 29, your lordships will see the variation 2011-12 and 12-13, the corresponding and comparative rates are given, my lords.
For example, take item number 3. What is this?
Item number 3, Arhar Dal. In
2011 and 12, 60 rupees.
60 rupees. And 12-13, it is 46.94, my lords.
Your agreement is for which period?
My agreement is for the 2011-12 period, my lords.
Correct.
So, but then in 2012-13, when
this is 2012 and 13 is a separate tender.
Separate tender, my lords.
Then how is it? How are you agreed?
No, because the central committee has interfered. Because of that, my lords.
No, whether central committee interferes or anybody interferes. The tender is for 2012 and 13. Price varies. You can't say that 2011 price is required to be quoted.
Lords, 2000. This is your lordship will kindly see at page 28. This decision is taken by Kendri.
Right. High Court 60 rupees, whereas now central committee is 46. Now, Where is the provision that district committee alone is required to fix?
At this very page, kindly have a look at page 28, the last item, clause number 3 of the proceedings. I am placing it.
No, you are saying that central committee has no power to interfere.
That is only the time limit is within 30 days it can.
Where is that? First of all, prescription that central committee is required to interfere before 30 days.
Kindly come to annexure 3 at page 25. I'll take your lordships to page 26, item number 2.
Page 26.
Lords.
26 or 36?
No, 26, my lords. The document starts at 25. I am taking your lordships to 26. The last sentence of this clause number 2, पुनरीक्षण का यह अधिकार क्रय समिति की बैठक के पश्चात 30 दिनों तक ही रहेगा. Only within 30 days they can interfere. Now, after a long time, he is issuing this circular that I was showing from page 28, my lords, where at page 28, the last...
2012 and 13, what is the date of tender?
Annexure 1 was the tender document for 2012-13 on 1st of February 2012. 1st February 1/2/2012.
What was the bid was opened or?
Various items are mentioned, my lords. Your lordships will see all.
Then how to calculate 30 days from so and so date to so and so date? How to calculate 30 days?
The district level had taken the decision. From that day, the central committee can interfere up to 30 days, not beyond that.
District committee took a decision for the year 2012 and 13 on what date?
On 21st of February 12.
21st of
February 21 to 2012.
What is the date of central committee?
And then your lordships kindly see in August at page 28 it will be clear. On 23/8/12, the central committee and the very item number 3 in that.
By the as on 23/8/2012, the pricing was finalized by the district committee.
Yes, that district committee's finalization was going on. Supplies cannot be stopped by the tenderers even for a single day.
Correct. Supply should not be disturbed.
Yes.
At the same time, contract commences on what date for 2012?
On 1/2/12, my lords, the date, very first day, 1/4/12. The period is 1/4/12 to 31/3/2013. 1st of April 2012. That is the period commencing.
For a period of 1 year.
For a period of 1 year. For one financial year. And they are taking this impugned decision on 23rd of August 12. And in clause 3, they are writing it will govern that earlier also.
So this is through auction process or how?
That this is through auction bidding. Bidding, open bidding.
Correct. If that is the case, how the district committee will fix the price? This is
no, this is at the district level. All jails district.
Correct, sir. District level, they fix a minimum price. Then it all depends on the bidder. He can quote higher than the minimum.
Lords, that was decided. There is no dispute on that, my lords. That what was the rate for each item?
No, what was the amount you bidded?
Lords, I had been successful in 4 items. There are, let us assume, 100 items. Each party can bid for as many numbers as it wants. So I had bid and I got 4 items.
Which are those 4 items?
Those 4 items, my lords, I have mentioned, my lords. They are, my lords, chakki good, that is peeling chakki good, chai patti, tea leaf, sarso tel, dhara bran, and milk powder.
Option B. Central Committee. Contract has been given. Oh, in the
What is this letter dated 23rd of August 2012?
This is the resolution of the
376.
Central Committee, my lords, the Central Committee. And if my lord would kindly have a look, my lords, kindly.
Where is your agreement?
Agreement, there is no such agreement. After the tender, it is announced.
Then where is the order asking you to supply from 1/4/2012 to 31/3/2013?
It's Annexure 2 at page 24. Wait a minute. Annexure 2 at page 24, my lords.
What is the date?
My lords, date is 1st of March 12 it is issued, and it is containing that for the period 1st of April 12 to 31st of March 13. On 1/3/12 itself it had been decided and communicated.
Then how they will overcome this?
This is what I submit on 23/8. That is complete.
Yes, Mr. State Council. Rightly or wrongly, you have passed an order asking him to supply 4 items during the intervening period from 1/4/2012 to 31/3/2013.
For financial year 2012-2013, my lord.
How can it be interfered by any third party?
My lord, the initial my district purchase committee of jail has fixed the rate, my lord, in consultation with the district magistrate, my lord.
No, such fixation could have been done before 1/4/2012.
That I am, my lord, I am draw your lordship attention, my lord. The Central District Purchase Committee, in consultation with the district magistrate, fixed the rate of item wise, my lord.
Correct. On what date?
Yes, my lord.
On what date?
I have stated in my lord the paragraph.
On what date, sir? Date is relevant. In the month of August 2012.
In the month of my lord, August 2000.
Correct. How can you fix in the month of August 2012?
My lord, kindly see paragraph 6 of my counter affidavit.
Please give the date, sir.
23/8/2012.
That is the reason. How? On 23/8/2012, you are fixing one item 46.94. Earlier it was 60 rupees. How the petitioner has to supply? He has already supplied on 1/4/2012 up to 23/8/2012. How can it be modified?
That is why, my lord, I am submitting before your lordship, my lord. What actually happens, my lord? The district purchase committee, in consultation with the district magistrate.
Correct. It should have been prior to 1/4.
Subject to approval of the Inspector General of Prison, my lord, in terms of Rule 1051 of the Jail Manual, my lord.
Within 30 days.
Sir, all right. You are right. But then why did you withdrawn this 1/4/2012? Supply order has been withdrawn.
I have clearly stated, my lord, that the 23/8/2012 new rate shall be paid as the Inspector General of Prison, my lord, has modified the rate because the order of the Inspector.
Sir, modification is subsequent to the order issued to him.
So that
have you withdrawn 1/3/2012 order?
That order has.
Have you withdrawn 1/3/2012 order asking him to supply?
I have no instruction to that extent, my lord. Because, my lord,
you have no instruction, we will allow the petition.
District Purchase Committee orders with regard to fixation of article wise price subject to final authority of the Inspector General of Prison, my lord.
Show us such condition is imposed in 1/3/2012 order. You have given supply order, no? In that, have you indicated these prices are subject to change?
Subject to approval of in terms of, my lord.
Sir,
yes.
Don't say show us 1/3/2012 order.
Sometime be granted, my lord.
Why it should be granted?
And I have, in pursuant to last order, my lord, I have filed counter affidavit. But to that extent, my lord's query,
the court's query has not been elaborated in the counter affidavit, my lord. So to particular extent, my lord, I am seeking instruction from the authority concerned as to whether that letter was withdrawn or not, or the subject to Inspector General of Prison.
You are supplied up to what date?
One thing he is missing. It was already approved by the district. My annexure 2 at page 24 itself contains क्रय समिति द्वारा अनुशंसा के उपरांत जिला अधिकारी मुजफ्फरपुर द्वारा अनुमोदित समेकित सूची recommended by the district committee and approved by the district magistrate, and then the rate was the annexure 2 at page 24.
That is true, my lord. The district purchase committee in consultation with the district magistrate.
So up to what date you are supplied?
For the whole financial year.
They have not paid you?
No. But according to the rate fixed on 23/8/12, Lords,
so difference of amount is yours?
Lords, yes, that is required.
To that letter, my lord, I am seeking a short adjournment with regard to seeking.
What are you going to do if we grant time?
For seeking instruction as to whether the first letter was withdrawn or not.
Thereafter, we will raise some other issues.
No, my lord. My lord. I will file detailed counter affidavit as also on the point, my lord. The similar identity matter has been decided by this honorable court. There against LPA has been filed, my lord.
LPA was dismissed, SLP dismissed.
So,
that order is there.
I also.
LPA is already dismissed, my lord. Again, the order of LPA.
Writ order we have annexed. You have said that of LPA and everything dismissed. Hello. You are SL. My reply to come.
I have just received my lordship.
वो extra copy दे रहा है. लगा है तो ये आप लोग
No, we are concerned. One. Please take on. The petitioner is one of the contractor for supply of certain materials to the jail. Which district?
Muzaffarpur district.
Muzaffarpur district. He is one of the successful builder for 4 items. Competent authority has issued a work order or / supply order on 1/3/2012 with reference to the price quoted by the district committee, read with the petitioner's acceptance. Such a supply of material is for the period from 1/4/2012 to 31/3/2013. When things stood thus, IG took a decision that whatever the price quoted for some of the articles were on a higher side. Therefore, he had given a proposal to alter such prices. For example, item number 3, Ahar dal, which was supplied by the petitioner at the rate of 60 rupees, and it has been modified to 46.94 at rupees 46.94. Such a decision is dated 23/8/2012. In the absence of withdrawal or modification of supply order or work order dated 1/3/2012. Abruptly, the respondents cannot alter the price of a commodity which is being supplied by the petitioner. Then counsel for the respondent is hereby directed to secure instruction as to whether pursuant to 23/8/2012 decision of the IG Prisons insofar as the fixation of price for various items, whether district committee has proceeded to withdraw the supply or work order dated 1/3/2012 of the petitioner. The further, whether retender process was ordered for the year 2012 and -13, that is after 23/8/2012 or not. On the other hand, the petitioner is stated to have supplied commodities for the entire year commencing from 1/4/2012 to 31/3/2013. In such an event, whatever the difference claimed by the petitioner is required to be extended to him. Really matter next week. Make clear that no further time will be granted for the reasons that matter is of the year 2015.
One thing more.
Similar matters had been already decided of others. Read aloud, their LPA dismissed. I have already brought on record in my reply that LPA order.
You replied?
Yes, I brought on.
The reply means what?
Reply to their
rejoinder.
Rejoinder.
Which paragraph?
Kindly. My rejoinder affidavit. That LPA order is, my lords, annexure 2 at page 10.
Paragraph.
Paragraph. I'll just now refer. At paragraph 8 of the rejoinder affidavit, it is annexed.
Para 8.
Lords.
That is the only para.
My lords, in the reply affidavit, that is the.
Correct. In that you have mentioned LPA and Supreme Court.
My lords, LPA order I have mentioned, my lords, and their SLA.
At this
my lords.
For the petitioner submitted that identical matters for subject matter of litigation before this court in writ petition, LPA and before the apex court. In this regard, the petitioner has stated in para 8 of the rejoinder. So therefore, fourth respondent, Inspector General, Jail Bihar Patna is hereby directed to file his personal affidavit as to whether the present matter is covered in favor of the petitioner or not.
Whether your IA has been disposed of, IA number 1 of 2022.
That may be done. That may kindly be allowed.
Bringing some fault.
The partnership fund,
IA number is 1 of.
Accordingly, cost title is on. No, the cost titles are here.
1 of 20. नहीं वो पार्टनरशिप फर्म
Not pending.
This IA is still pending.
That IA may kindly be allowed because in view of.
First, you before addressing the argument, all pending IAs you should highlight. Otherwise, without that, if we decide the main matter.
No, that is mistake, my lord. Actually.
Notice has to go.
No notice, my lord.
No, this affidavit for IA is filed by whom?
This is filed by the substituted partner, Rohit Hora. Earlier it was Harish Kumar Hora.
No, how can Rohit Hora will file? It should be filed by the Harish Kumar Hora.
Pandal has been filed by Rohit Hora.
Then it will file notes another.
And rejoinder is filed by whom?
Rejoinder reply.
Rohit Hora. How can it be?
By this person only because he has.
Rectify that. Next date we are going to reject.
Now we will rectify. उसी का affidavit कराना. जो original petitioner. By the original petitioner will get affidavit.
Serial number 15, Dilip Maroja versus the State of Bihar for the petitioner Sri Rajesh Mohan.
So this is 2015 matter, Your Lordship. We have no instruction. This is not what happened there.
Matters have become infructuous, Your Lordship.
Fructuous.
Your Lordship.
Regarding work has been completed.
But Your Lordship, there is something. Honorable High Court is upheld, Your Lordship, Annexure 7. Kindly see the Annexure 7, Your Lordship.
What is your prayer, sir?
For crossing of Annexure 4, Your Lordship. Why there under page 23.
What is this?
This is a list of two bidders, Your Lordship.
You are asking for quashing this?
Lordship. दिलीप मरोजा अरवल संवेदक का निबंधन दूसरे जिले का है ऑन दिस ग्राउंड दे हैव रिजेक्टेड माय candidature for submission of tender.
Is there any interim order?
No, Your Lordship.
Then it has become infructuous. In the instant petition, petitioner has prayed for the following relief. So, with the perusal of the records, it is evident that there is no interim order. Therefore, the relief sought by the petitioner do not survive for consideration. Accordingly, writ petition stands dismissed as infructuous.
Serial number 16, Harish Kumar Ojha versus the State of Bihar for the petitioner Sri Rajesh Prasad Singh.
Review in the annexure 1 miller. Bench miller order to appoint the appellant miller by 9. Relevant part, page 62 miller.
What is error committed by the earlier bench?
New point has been raised by the State Council. New point raised by the State Council in LPA number. The circular has been raised.
LPA new point has been raised.
Yes, sir.
What is that new point?
One circular has been by annexure 1 miller, kindly see para page 32 miller. Para 2 miller. Circular dated 27th March 1992. This is a new issue, miller.
Oh, what is wrong with this?
My prayer only, Lord, by passing the order by annexure 9.
No, the LPA bench has held that single judge has failed to take note of circular number 27/3/2022, 92. In terms of this 27th circular, such of those persons who have attained age of 33 years and above, they are entitled to weightage of 2 marks. Your petitioner was not. Petitioner age is less than 33 years. What is wrong in it?
My prayer, in annexure 9, Honorable Court has already decided, my lord. By annexure 9, my lord, the Honorable Single Bench has ordered to appoint the petitioner, my lord. Or not this matter has been raised by the State Council. He was also present at that time, my lord.
But it is a material on record. We can't go beyond this. This was not taken note of by the learned single judge. Can we ignore?
A simple claim, my lord, it should be considered. Give liberty to the appellant, my lord, to file a petition before the authority concerned, my lord.
Anything else?
Only prayer, my lord.
Only prayer.
Some liberty to given to appellant, my lord.
Is taken. The present civil review application is arising out of LPA number 1830 of 2012 in CWJC 5089 of 2006, decided on 29/2/2016. The present review is filed on the sole ground that LPA bench has considered extraneous material, namely circular dated 27/3/1992, and it is submitted that scope of LPA bench is only to examine whether the order of the learned single judge is in order or not. LPA bench, the extract of the LPA bench reads as under page 32, mark portion, pencil 32 and 33. Perusal of the aforesaid finding that the LPA bench has taken note of circular date 27/3/1992 to the extent that review applicant herein is not entitled to weightage of 2 marks to stop. The learned single judge has not taken note of, in other words, 27/3/1992 circular was existing as on the date of deciding review applicant's writ petition. By oversight, the state respondent in writ petition have not brought to the notice of a circular dated 27/3/1992. Therefore, there is no infirmity in the LPA so far as taking note of circular dated 27/3/1992 while denying relief to the review applicant. Hence, petitioner / review applicant has not made out a case so as to interfere with the order dated 29/2/2016 and recalling the order passed in LPA number 1830 of 2012 dated 29/2/2016. Civil review stands rejected.
Serial number 17, Vinod Kumar Singh versus the State of Bihar for the petitioner Shri Virendra Kumar.
With respect to the last order, district magistrate was required to file personal affidavit showing compliance with the order. My lord will see the order that content. The district magistrate was directed to dispose of the representation and milords, equally milords to carry out the repair work also.
Now, district magistrate has filed affidavit.
Yes, personal. 1 milords 26, 4 milords we are filing personal. Supplementary so-called my lord will have. If personally made a visit, my lord, and he found that, my lord, the repair work was carried out in 2019 and thereafter, my lords, no damages is caused to that, my lords, Zamindari Ban. And even, my lords, this petitioner was also, my lords, approached and he was asked about any, my lords, grievances. He could not come up with any such grievances. Some rain cuts, my lord, that was found at the spot, but my lord, that is very natural.
My lord, earlier, my lord, the similar type of affidavit has been filed. Requirement of repairing of embankment of the river, my lord. Earlier in 2012, my lord. Thereafter, the petitioner opposes the statement of the.
Where is the order of this court?
My lord, the page 12.
Page?
Page 12 of my lord's the main application, contempt application. No, sorry. It's page 7, sorry.
Page?
Page 7, annexure 1.
Page 11 is there.
No, I'm sorry, page 7.
Page 11 of the contempt application, my lord.
Oh, contempt petition pleading itself is there, page number 7.
Yes.
No, they are asking where is the court order.
Annexure
Page
1.
11, my lord, annexure 1.
It is page 11 and 12.
My lord.
Yes.
3/10/2012.
How contempt is maintainable?
My lord, it was the public interest litigation, my lord.
So what?
My lord, the
order is dated 3/10/2012. The contempt is filed in the year 2016.
earlier, my lord, the repair work was not done, my lord.
Correct, sir. How do you overcome delay? 1 year. Within 1 year, you have to file. Have you gone through the provisions of the Contempt of Courts Act 1971? Therefore, we will on that ground itself we reject.
Lord, the liberty may be given to the petitioner, Lord, to file.
Liberty is always there. You can go and file a fresh petition.
Large number of people, my lord.
Sir, you can go and file fresh petition, sir.
Liberty may be given.
No, where the question of liberty? It is always there.
If, my lord, the petitioner agreed, my lord.
You people don't look into the judicial pronouncement and come and address the argument here.
Cause of action, my lord, the large number of people.
Sir, there is a Supreme Court judgment. You have to make some certain research.
Earlier,
if you are unable to file contempt petition within 1 year, you have power to file a fresh petition.
My lord, since 2016, my lord, the number of the benches, my lord, that were
Yes, taken. the present contempt petition is filed in the year 2016 insofar as order dated 3/10/2012 passed in CWJC 18627 of 2012. The contempt petition itself is not maintainable since it is beyond the limitation period under the Contempt of Courts Act 1971. Be that as it may, in terms of latest affidavit filed on behalf of the district magistrate, this is Shokas, but this court has asked him to file affidavit. Shokas and affidavit of district magistrate Patna dated 26/4/2023. Evident that there are complaints to the orders of this court dated 3/10/2012. The petitioner feels that he is not satisfied with the contents of the Shokas dated 26/4/2023 of the district magistrate Patna, that liberty to file fresh writ petition. Accordingly, the present contempt petition stands offered.
Here number 18, Dinesh Kumar versus the State of Bihar for the additional fee.
My Lord, may kindly see. My Lord, may kindly see order dated 13/4/2023.
In the instant case, my Lord, I am appearing on behalf of the petitioner. I be permitted to crave the court and judicious indulgence of the Honorable Court, my Lord, how the opposite party deliberately and willfully they are not going to. अरे तो मैं petitioner को बोलने दिया है, कौन तरीका है?
My Lord, may kindly see.
Where is the order, sir?
My Lord,
Yes,
may kindly see.
may kindly have the order.
My Lord, may kindly see order dated 13/4/2023. He is first time appearing in this case, my Lord. This case is going on, my Lord, for since long. My Lord, may kindly see order number 14, 13/4/2023.
Order number 14.
14, my Lord.
What is this?
My Lord, there was a direction in compliance of this order. We issued letter of his appointment. He did not join the place. This, when the contempt was filed, this Honorable Court directed that produce the record whether he was doing the job or not. I produced on record, my Lord, each and everything that he was not joining at the place where he was directed to join. And my Lord, he is claiming he has filed a reply without annexing anything, my Lord. And he is claiming salary for that, my Lord, that period.
Your Lordship may kindly have the order.
That is the first. Where is the order of this court?
Yes, my Lord. Your Lordship may kindly have in my contempt petition, my Lord.
Page number?
Page number 11.
11.
Yes. Your Lordship may kindly have the operative portion.
Sir, allow us to read, sir. We will look into
it. Oblige. Sorry.
Where is this 31/10/2013 order required to be implemented annexure to the writ petition?
That is in the read case, my Lord. That is in Hindi version, vernacular.
Huh?
In annexure 2 of the read petition.
Where is that?
Page 14.
Page 14.
Yes, of the writ petition. Annexure 2.
No.
Although I be permitted to supply the, but it is in Hindi, my lord. May I permitted to read out the.
Pass on that.
Registrar had already passed the order, my lord. Then thereafter, managing director had making a clarification, and he had made.
Sir, first we have to understand your case, sir. Then only we will.
Yes, my lord. Yes, my lord.
Statement is that
Only payment of salary.
payment of arrears of salary. Since for which period? No, that means salary is required to be paid.
Salary is required to be paid during which period?
My lord. Or it is for the November 1987.
November
1987.
87?
Yes, my lord. Because he was regularized in 80.
All right, now from November 87 to?
Till date, my lord.
Till date, they have not paid you salary.
Yes. And he had already been superannuated, my lord. And your lordship may.
What is the date of annexure 2? 2 is 31/10. When did you approach this?
Yes, my lord. Your lordship may kindly have.
No,
Annexure 2. Annexure 2, page.
Sir, 1 second.
Petition.
Please listen, sir, I say. When did you approach for the first time before the authority claimed salary?
When the order was made by the Honorable Court, my lord, LPA Court, my lord.
You are not answering properly. You say that you are not being paid salary from November 1987. For the first time, when did you approach the authority demanding salary?
Application. Debits of
My lord, that's why. That's why, my lord, I was referring order dated 13/4/2023.
What was your earlier rate petition
My
number?
lord, that's why I was referring 13/4/2023 order. This honorable court considering after that everything, my lord, the order was passed.
We can't go beyond this earlier order. Earlier order means the subject matter of contempt. Earlier he has approached this court in 2010. There is a reference in this order. You are not opening your mouth if you are aware.
What are you asking from me, my lord?
May kindly have the
My lord,
operating
my lord,
portion of
I have filed so-called, my lord, in compliance of order passed by this honorable court. My lord, may kindly see.
Sir, for demanding salary, he had approached this court earlier in 2010.
My lord, may kindly see annexure A of my so-called. What is happening?
Content matter re-arguing on merits?
No, not on merit, my lord. In compliance of this order, we issued an order giving the appointment letter to come and join the office. He is not joining the office without doing any work. He was want to get salary, my lord. In the garb of contempt application, my lord. That's why the 13/4/2023 order was passed, my lord. Section A, my lord.
You say that he has not worked from 87 to?
He has not worked. My lord, we have annexed, my lord, this honorable court 13/4/2023. This honorable court directed me that produce the attendance register. I produced the attendance register, my lord. He has not controverted that. He has filed the reply for the same. He has not controverted. In the garb of contempt application, without doing any work, my lord, he want to take the salary. My lord, this command is a cooperative society, my lord.
Your lordship may kindly have the operative portion of the LPA code.
No, where is the material to show that you have discharged the duty?
Yes, your lordship may kindly have annexure 2 of my contempt petition, page 18.
What is this annexure 2?
Presentation was made keeping in view of the division bench order, my lord, made a request that my salary, which is pending with the department managing director, has been addressed, my lord. And again,
no, you are not answering the court question. Where is the material to show that you have discharged the duties of the post?
My lord.
When the order was made by the LPA court, my lord, immediately.
All right, we will say that it is impracticable to implement the LPA order.
Yes.
We will reject your petition, contempt petition. Because you have not discharged the duties of the post. Where is the question of payment of salary?
I am asking for the services for which I had already given the service, my lord.
Where is that? Assuming that up to what date you have worked, you show us the material.
So you have supplementary में दे देते हैं detail.
Every time he was taking time, my lord. He is not producing time and again.
And I will.
My lord, may kindly.
the version of the annexure, I will.
My lord,
also
may kindly
translate.
13/4/2023 order, a specific order. He has to produce those evidences. He has not produced, my lord.
My simple request is before the honorable court, my lord. LPA order was passed. Along with the LPA, representation was made to the managing director repeatedly 3 times, but they are still keeping mum. They are not come out with any version. Neither the order has been complied nor any reply has been given by the managing director, my lord, till today. It is a clear-cut deliberation. Obstinate attitude are shown by the opposite parties, my lord.
Where are the documents to show that you have the work?
Yes, my lord.
Show us.
This is the pertinent question which my lord has put to him.
For that purposes, my lord, I will file a supplementary petition in detail. Some time is required.
Along with the documents.
Along with the documents, my lord.
Document तो हुजूर इनके पास सारा है.
हाँ?
इनके पास all documents are. He is the custodian of my all the documents.
All right, submit application or RTA and obtain. They will provide you.
4 weeks time may kindly be given me.
We'll grant 8 weeks, but see that you should file all those documents.
But so far as the deliberation is concerned,
What are the documents you have produced stating that he has not? What was the post held by him?
My lord, in compliance of order passed by, I filed supplementary, so-called my lord, supplementary, section J, my lord, page number 6. I have annexed all the attendance register, my lord, from 2017 after 2018. There is no marks, my lord.
No, sir. Between 87 to 2013, where is the document?
This honorable court has directed me to file the affidavit after 2000.
So his claim is to 87.
His claim is totally bogus, my lord. He has not discharged duty, my lord. Even in the.
All right, sir. Why don't you produce those documents?
My lord, in thereafter, my lord, he has filed reply of Masokas. He has.
Sir, why don't you produce the document?
My lord.
All right. From 2013, he is not entitled according to your record. Prior to that, is he not entitled?
For that purposes, my lord, I am
directing the petitioner, my lord, let him produce the record.
No, how can you? He is a night guard. Is he custodian of those records? Is he custodian of the records?
वो लोग हुजूर मिलते नहीं.
From what date you have produced stating that he has not worked? 2017.
17.
Between November 87 to 2017.
My lord, 87 he is asking, my lord. I am not on that, my lord. 87 he is working or not working, my lord. I will ask.
No, in terms of this, what he has produced that? Where is that?
10/2013.
ये ऊपर ऑर्डर में ही है.
No, where is this 31/10/2013 order cited in the LPA bench? On page 17.
Yes, my lord.
Where is this copy? This court has directed to implement 31/10/2013. Both of you have not produced that. That is the crucial document. And matter is pending since 2016-18.
My lord, in compliance of that order, my lord, Annexure A has been passed. You may kindly see.
Sir, you have no voice because you have not produced the relevant document.
My lord, I have.
The present MJC is pending consideration since 2018. Question is whether respondents have implemented the respondent society have implemented the order 31/10/2013 of the Register of Cooperative Societies. By which Register of Cooperative Society has directed the respondent society to settle the petitioner's arrears of salary. Learned counsel for the respondent submitted that the petitioner has never worked as a night guard.
I may be permitted, my lord, in compliance of order passed by this honorable court, my Annexure A may kindly be seen, my lord. By Annexure A, I directed him to come and join the office where he has to work. My lord, he did not join, he never come, my lord, and that's why the order was passed. My lord,
this order says that asking him to...
My lord, I am accepting, my lord, I am accepting. But
you can't take extraneous material. I will record your submission. What is it?
Petitioner has never worked as night.
Never worked as a night guard. In such an event, a respondent society should have asserted the order of Register of Cooperative Society dated 31/10/2013 in the manner known to the law. For the purpose of implementation of orders of this court dated 30th August 2017 passed in LPA number 731 of 2017 read with the Register of Cooperative Society order dated 31/10/2013. The learned counsel for the respondent submitted that in terms of Annexure A to the show cause notice, the petitioner was asked to join the service and he failed to join the service. In the present contempt petition, it is not question is not relating to joining service. On the other hand, question is payment of arrears of salary in terms of the cooperative register's order dated 31/10/2013. Order of the cooperative register dated 31/10/2013 reads as under. Therefore, prima facie, the respondent society have not implemented the orders of this court.
not working, my lord.
Dated 30th August 2017, read with the orders of the Register of Cooperative Society dated 31/10/2013, cited supra. For compliance, release this matter after 4 weeks, failing which the concerned society respondent shall be present in the court along with the complete records.
My lord, petitioner is not working, my lord. My lord has observed he is not working, my lord. How the payment should be, my lord has observation is coming from the my lord. He is not working, my lord. Just contesting the matter in the court, my lord.
Can this contempt court go beyond 31/8/2017? Then what is the remedy you have? What is the remedy you have?
I'm not saying, my lord. I'm not saying
you invoke the remedy, sir.
I'm not saying, my lord. My lord, observation is coming from the my lord. He is not working. How he will get the salary even 2017?
Shall I record that also?
My lord, after
All right, you want me to record that also?
My lord, after order passed by this honorable court in 2017, we asked him to join. He is not joining. My lord, my lord.
How is it material?
My lord, it is.
How is it material?
My lord, to whom? My lord, when he is not doing any job, my lord, to whom? My lord, he is a night guard. That's why on the.
Sir, why don't you settle his salary up to the date of the LPA order?
My lord, what I am trying to submit, my lord, thereafter, my lord, in compliance of this order, we.
At this stage, the Land Council for the Respondent Society keep on arguing that the petitioner failed to join service. However, we have made it clear that the contempt matter is not relating to joining of service of the petitioner. On the other hand, it is relating to only payment of arrears of salary. Accordingly, it is hereby rejected.
My lord, my lord, it was also stated in that कि after your joining we will consider and accordingly, my lord, may kindly see that is Hindi, my lord. समीक्षो परांत नियमानुसार की जाएगी. We are ready to pay, my lord. He is not coming. Where we will go to, my lord? He is just coming in the court, my lord, and just we are pressurizing us.
Respondent council keep on arguing the matter even after passing the above order. Therefore, respondent society are liable to pay cost of.
My lord, please.
10,000 for abuse of court process.
My lord, please, my lord. Please, my lord. Please, my lord. My lord, please, my lord. Cost may kindly be.
Sorry.
Case number 19 for the petitioner's fee.
Your Lordship, this case has been sent to the mediation, Your Lordship. This case is sent by order of this court of mediation, Your Lordship.
Now, what happened before the mediation?
Still talk is going, Your Lordship.
Still?
19th May, next date has been fixed by the mediation center, Your Lordship.
Parties have appeared on 21/4/2023 before the mediation.
My lord.
What happened?
Still some progress has been made, Your Lordship, but final has not done away.
Did you appear before the mediation? Then what is the outcome?
Then still talk is going between the party, Your Lordship. Still talk is going between the party and Your Lordship regarding the payment of the.
Therefore, mediation has referred back the matter to this court.
No, man. Still.
What is the order passed by the mediation?
Still, there is no order passed by next date and fixed 19th May, Your Lordship.
How can mediation give date without the permission of this court? This court has given a specific date on 21/4/2023. What business mediation has got?
On the submission of the respondent, Your Lordship, that with the consent.
Registry is hereby directed to secure orders passed by the mediation and conciliation center of this court dated 21/4/2023. Release this matter next week.
Case number 20 is fixed for 2:15 p.m. Case number 21. Case number 21, Visesa Rani versus the State of Bihar for the petitioner's fee and Rishabh.
May I please, Your Lord, this case is Milord. The petitioner Milord has joined in the Bihar military police in the year 2007, Milord. Thereafter, Milord, after 1 month, Milord, his service has been terminated, Milord. And Milord, the petitioner Milord approached before this honorable court, Milord.
What was the relief sought by you before the single judge?
Lord, for reinstatement of service, Milord.
That means you have been
Lord, after
terminated.
Service has been terminated, Milord. This honorable court has directed, Milord, to reinstate the petitioner, Milord, in service, Milord, within 2 months, Milord. The order, Milord, passed in the writ application, Milord, is an XR 16, Milord, which is at page, Milord, 57, Milord, of the writ application.
You file contempt?
Lord, I have filed contempt, Milord, and Milord, contempt court has, Milord, taken on view. Another selection has been done, Milord. Therefore, my case has been considered, Milord, to reconsider in the writ application, Milord. Thereafter, Milord, I have.
What is you are asking for review of review order dated 3/2/2021. On what ground you are asking us to review?
Lord, In annexure,
Not annexure. From the impugned order, you point out in which paragraph LPA bench has committed error.
Lordship. Para 3 of my the judgment, my lord, impugned order, my lord, from top, my lord. It was found during inquiry that.
Wait. Page number?
Page number, my lord, 3 of the impugned judgment, my lord.
It was found during inquiry. Yes.
That name of the appellant was wrongly entered in the merit list prepared by Beltran, and consequently the selection committee central range board number T3 filed memo number 985 dated 8/10/2007, my lord, declared the appellant as successful, and when the mistake was detected on the basis of complaint filed by the Manisha Kumari, the recommendation with respect to appellant was withdrawn by selection committee, and accordingly the selection of appellant was cancelled. It was further revealed that out of the 3 female candidates whose name was recommended by the selection committee by memo number such and such, only Manisha Kumari joined the service, and due to non-joining, selection committee recommended the name of Ranjita Kumari and Bina Kumari. But Lord, this candidate was not at the time in the picture, Lord, at the time when my writ was allowed. My writ was allowed, Lord, earlier, Lord. After setting aside all the dismissal order, memorial order, and appellate order has been set aside by this honorable court, by annexure 16 of the writ application.
So when were you appointed?
Well, Lord, not appointment.
Then how can you say termination, dismissal? You are using the word as if you are appointed. This is matter relating to selection and appointment. You are not being selected.
I have been selected, and I have joined. I have joined, Lord.
Joined on what date?
On my lord, 8/10/2007, my lord.
8/10/2000?
2007, my lord. And thereafter, my lord, on 9.
Then where is the termination order?
Lord, termination order is, my lord, writ application, my lord, annexure, lordship. Annexure 3 of the writ application, my lord.
Selection was cancelled on 20th December 2007.
Before that, my lord, annexure 2, my lord, by annexure 2, my lord, the authority has passed order, my lord, Danti Kumari.
Respondent, counsel, where is the merit list?
My lordship, so many writ petitions filed by the petitioner and.
All right, you show us where is the merit list.
Then sometime.
The merit list, have you altered, reviewed?
Sometime I mistaken, Belton by the.
All right, sir, assume.
The petitioner, my lordship.
Correct, whatever it may be, right? Please listen.
Yes, ma'am.
Rightly or wrongly, his name has been included, her name was included, and later on you notice that there was some error. Then are you not required to modify the select list? Because she was selected and appointed.
Yes, modified, my lordship.
Where is this?
My lordship, can you see the order of the writ application, the detailed order passed by the single.
Show us, that is the reason I am, show us, where is the revised select list?
At complaint, contempt stage, my lord.
My lordship, CWJC number 10745 of 2015, order dated 2/4/2019, permitted to read.
What is the date? Please answer. What is the date of revised select list?
My lord, after filing the earlier writ application, CWJC number 10272 of 2010, my lordship.
What is the court is asking you, Mr.?
My lordship, certain verifier searching that, my lordship.
We'll come back after 10 minutes. You point out. Take page number 3, read para 3.
No, sir. Page 3 of the impugned order, Your Lordship.
Page 3 you have impugned order.
Lordship.
LPA.
Lordship.
Page number 3, para 3.
Lordship. Lordship. It was further.
Where is State Council? Disappeared.
Yeah. I had to.
All right, we will wait for him. You read.
Lord, I am giving.
Sir, read, sir.
Lordship, Lordship. It was further revealed that out of the 3 female candidates whose names were recommended by the selection committee by memo number 1046 dated 14/12/2007, only Manisha Kumari joined.
Read, sir, don't.
Service, and due to non-joining, selection committee recommended the name of Ranjita Kumari and Bina Kumari. That is.
Read further, sir. Why you are? Please don't give explanation and all.
Sorry, who were appointed against the vacant post, and even one Kalpana Kumari not appointed was placed higher than the applicant in merit.
All right, now stop at that. How do you overcome this? What is wrong with this?
Lordship. Lord, earlier, my Lord, brief facts of the case is, my Lord, the petitioner has joined on 19.
Sir, show us the merit list, sir.
Lordship.
Show us the merit list.
Lord, merit list, my Lord. Lord, he will give me, Lord, merit list.
Without merit list, how did you approach this court?
Lord,
you are the petitioner, no?
Lordship, in the writ application, my Lord, your Lordship, permit me, my Lord, to read the writ application, my Lord. I am drawing your Lordship attention, my Lord, on annexure 1, my Lord. By this letter, my Lord, this petitioner has been appointed, my Lord.
Sir, again you are saying same thing. We are asking you, where is the merit list?
Okay. My Lord, merit list has been annexed, my Lord, in my Lord, counter affidavit of respondent number 5, my Lord, annexure A series, my Lord.
Counter affidavit?
Of respondent number 5, my Lord. In the writ application. Merit list, my Lord. My name is, my Lord.
There is no merit list here. It is only a counter affidavit. Respondent number 5.
Annexure A, my Lord, has been annexed, my Lord.
And annexure?
Annexure A, my Lord, which has been annexed at page 35, my Lord.
My Lordship, presently I have no record, but order dated 17/2/2020, challenged by the petitioner through IA number 3163 of 2018, in the writ CWJC number 19754 of 2015, my Lordship. IA number. We'll close the impugned order. ये लिखा है ना रीट का है
Why? They should show the name. Non also. Reason.
In view of the aforesaid direction, the order dated 17/2020 has been to well issued by the authority rejecting the claim.
Where is the comparative merit list, I say?
Sometime will be granted to collect the entire record at the proper.
For the entire exercise.
unless permitted to some exact part of the writ order. Submission made by the counsel for the petition was tested by the court of the contempt proceeding arising out of MGC number so and so in the light of direction contained in CWGC of 2010. The contempt proceedings were disposed of by this court, order dated 7/3/2020. Relevant exact of the same is being recorded. Now, the submission of the petitioner counsel that the order dated 17/2/2012 was not in compliance with the order passed by the CWGC number so and so has thus been negated by the order passed in the contempt proceedings. Instead of responded that person above the petitioner at serial number 9 and 10 have been appointed against the two existing vacancy has been considered to be a valid defense. It was only correction of the decision which was left open. The petitioner hesitate in writ petition if the petitioner is agitated by the such decision. In the circumstances, the assertion of the petitioner that in light of the order dated 13/3/2011 passed in...
Why the petitioner was unsuited, sir? You are saying that only a mistake.
No, my lordship, only mistake.
Only mistake. What is that mistake?
Presently, I have not entire record, my lordship. But
my lord,
that is not a case of the petitioner. Only 10 seat reserved of the women candidate, my lordship. Wrongly, he was recommended by the Beltran.
Correct, sir. What is the mistake committed by them?
My lord,
you also showing
the lordship attention, my lord. Annexure 2 of the writ application, my lord. What he is saying, my lord.
Before your termination, notice was given.
Annexure, no notice was given.
My lord.
No notice was given.
Properly
Where is the notice? Show us the notice.
My lordship, one time read the writ order, my lordship, which challenges the impure order, my lordship. CWGC number 19754 of 2015. Order dated 2/4/2019. Entire fact given by the single judge, my lordship.
If she was having lesser marks, how she was selected?
One Manisha Kumari and Kalpana Kumari,
they made the complaint, but how this list was prepared that those who got higher marks, they were not selected, and those who got lesser marks, they were selected.
My lordship, like I will see, year number 3163 of 2018, that impugned order which was issued by the authority concerned, order dated 17/2012, is enclosed and challenged by the petitioner through that IE. IE number 3163 of 2018 in CWGC number 1975 of 4 of 2012.
Sir, you are not able to apprise this court what error committed by the...
Lordship, Annexure 2 of my writ application, my lord, I am drawing your lordship attention, my lord. Annexure 2 of the writ application, my lord, passed by, my lord, order passed by the commandant of Bihar military police, my lord. Three candidates have come before the commandant, my lord. My candidature should be treated as a valid, my lord. Shanti Kumari, Manisha Kumari and Sangeeta Kumari. There are three candidates in the picture, my lord. And thereafter, my lord, after...
Where is the revised select list?
Lord, Annexure 2, I have submitted, my lord. Annexure 2, page, my lord, 2014.
You will not interfere.
Facts is this, my lord, and entire...
You are not able to apprise this court. What is the error committed by the LPA bench?
Lord, Annexure 2 has been passed, order passed by the authority, my lord. Annexure 2, my lord, in the writ application, my lord, there are three candidates, my lord, came before the commandant, my lord. And my lord, Shanti Kumari, Manisha Kumari and Sangeeta Kumari, my lord.
Yes, see, they have been the petitioner.
Rukiye,
What is the mark secured by you?
Lord, thereafter, my lord.
What is the mark secured by you?
My lord, I am not challenging my marks, my lord. And I am.
Sir, you are not challenging. We want to know where you stand.
Lord, your lordship permit me, my lord.
Nothing has been produced.
Annexure 17, my lord.
When counsel for the respondent state is hereby directed to secure a revised select list and so also comparative merit.
Your lordship.
So as to understand the case whether the petitioner is more merited than the last selected candidate or not.
Lord, there is a case of reinstatement, not, my lord, selection, my lord.
Sir, we want to see the revised select list.
No, my lord. I am not.
We will dismiss this.
No, no. My lord.
What? No.
Annexure 16 may kindly be seen.
Sir, you want
1 minute.
Order or shall we dismiss?
Lord, the honorable court, my lord, has set aside all the orders, my lord, dismissal order.
Yes.
And thereafter, my lord, the honorable court has passed order, my lord.
Sir, you are not able to apprise this court what is error committed by the LPA bench.
Lord,
you are re-arguing the writ petition.
There is only question before the LPA court, my lord, whether the case of petitioner is reinstatement or reappointment, my lord. My case is for reinstatement, my lord. And my lord, the honorable Supreme Court.
Sir, that is the reason we are asking you. Show us the merit. You are more merited than last selected candidate.
Not more merited, my lord.
You are saying orally. Where is the document?
Not orally, my lord.
Then show us the document.
At that present, I am unable to show in that document, my lord.
This next week.
My lord.
Number 22, Inputaman versus the Bihar State Power Holding Company Limited for the appealant Sri Kumar Kaushik.
May it please your lord. Before the indirect petition, the order of punishment by which one increment was withheld without cumulative effect was under challenge. The petitioner is an accounts assistant working in the respondent Bihar State Power Holding Company.
What is wrong with it?
My lord, a show cause was issued on 11/4/2018 on the basis of a letter written by an executive engineer to the superintending engineer requesting that departmental proceeding may be conducted against the petitioner. In that request letter, in the last paragraph, there were 4 charges framed. And thereafter, my lord, a show cause was issued on the basis of that letter. And in the show cause, it is stated that a department...
11/4?
11/4/18.
2018.
2018.
Under which provision?
My lord, it does not say it is in my submission, it is a show cause notice in the nature of preliminary inquiry. It says that a decision to conduct departmental proceeding can be taken against you and reply within a period of 15 days, failing which it will be understood that you don't have to say anything and once a unilateral decision will be taken. I responded to this show cause on 26/4/2018 and then an order was passed on 5/7/2018 imposing the penalty without assigning any reason, without considering any point in the show cause notice.
Where is the punishment order?
My lord, in the writ petition at page number 25.
My lords, my writ lords file is not here, my lords. My writ file is not here, my lords.
We'll examine.
My lords.
Court officer, give it to him.
Is considered and it shows the fraud innocent in the 15.
No, the problem, you see the reply, what point he has raised. This is only respondent counsel, in the punishment order, where is the reference and discussion about his reply?
So I have to submit.
No, from the order itself you see.
My file, my lords. My file.
Huh?
My file, my lords.
Where?
My lords, official file, my lords. Let me pass over for that.
There will be a difference between your official and our court order.
I have gone through my entire records. my lord.
Now go through that, page 25. It is a half a page. It is a non-speaking order.
And apart from this, my lord, statements of imputations of misconduct, charge sheet, those were not
required.
My lord,
If they are in their disciplinary authority's intention is to impose minor punishment, he has a power to only issue show cause notice and obtain
under CCA Rule 16, Rule 19, my lord, statements of imputations of misconduct is required.
No, you are a government servant.
My lord, and for in the present case, there is a standing order which requires a departmental proceeding for even withholding one increment without cumulative.
Government order will not prevail over the rules.
My lord, standing rules of respondent corporation.
Sir, it will not override rules. Rule will prevail.
Rule may also be seen. Rule 19. Procedure for imposing minor penalties.
Rule 19.
My lord. Subject to the provisions of Sub-Rule 3 of Rule 18, no order imposing on a government servant any of the penalties specified in clauses 1 to 5 of Rule 14 shall be made except after informing the government servant in writing of the proposal to take action against him and of the imputations of misconduct or misbehavior on which it is proposed to take action.
Yes, what do you say? Rule 19 1B.
B, my lord, is applicable when the disciplinary authority
19(1)(b). J. Informing government servant in writing the proposal to take action against him and of the imputation of misconduct from his behavior on which it is proposed to be taken. May wish to make against the proposal. Holding an inquiry is there.
B may not be applicable, my lord.
And if concerned so far notice reply and proceed to further. Down. Every authority has to form an opinion, but has formed an opinion that it is not a case of inquiry. You get the original records relating to departmental inquiry.
Inquiry, my lord, was not conducted.
No, all right. We want to know the file because the authority is required to form opinion whether it is a case for departmental inquiry or not.
Fine.
And counsel for the respondent is here directed to secure original file relating to imposition of penalty in order to ascertain whether disciplinary authority has expressed his opinion that it is a case of not holding inquiry, that it is a case of no, disciplinary authority is required to form his opinion as to inquiry is necessary or not. Under Rule 19(1) within bracket small b of Bihar CCA Rules 2005. To which
Palace.
Right.
Number 23, Extra Security and Intelligence Services versus the State of Bihar for the National Package Diwali.
Yes, Your Lordships. Your Lordship will kindly have pleasure to see order number 11 dated 17/2/23 minutes.
Order number
11 dated 17 February 2023. We complied this order, my lord. We have brought on record the documents, my lord, sample documents that we have been paying EPF and ESIC to all our workers, my lord.
Where is the document?
Your Lordships, kindly have pleasure to see our supplementary affidavit. We have brought on record. This is one, bulky. Thickest one, my lords.
When did you file?
Lord, this was filed way back, my lord. My lord, on, my lord, 28th March 2023, my lords. Rather 28th February itself. 17th order was passed in compliance to that. This was filed, my lord. May I pass on a copy, my lord, to your lord, for lordship's kind perusal?
Not there.
Hard copy.
Okay, fine.
Fully filed after service. Copy.
Registry is hereby directed to supplementary affidavit stated to have been filed by on. When did you file?
Lord, we have filed it on 28th February.
20th February 2023. Matter next week.
Next week, can it be on Tuesday, my lord?
Huh?
On Tuesday next week.
Next week, Tuesday.
Tuesday. I am deeply honored.
Serial number 24, Mrs. Nizam Printers and General Order Supplier versus the State of Bihar for the petitioner Sri Sanjeev Kumar.
Your Lordship, for present, all the grievances have been redressed. I want to withdraw this writ petition.
Withdrawn.
Now the government has decided, my lord, that not to go for the fresh tender.
Fresh tender.
Government has decided.
Serial number 25, Ram Bahadur Singh versus the State of Bihar for the petitioner Sri Vinodan Misra.
I'm appealing for the Commissioner, Lord. By last order, Commissioner, I'd like to file counter affidavit, posing some questions, Lord. Do I have filed my counter affidavit? But I found that the informations which were directed, they are some sort. I want to file a supplementary counter affidavit, Lord. Sort, Lord. One annexure also, which I have discussed, but not annexed, my lord.
You have filed?
Do I have filed, Lord, but I want to file a supplementary affidavit because some point I have not discussed in my counter affidavit.
For the respondent seeks time, file at another supplementary matter after 2 weeks.
Right.
Serial number 26, Viman Kumar Singh versus the State of Bihar for the petitioner Sri Satish Kumar Singh.
May I please, Your Lordship? E-tendering, and he was the lowest bidder. But the work order has been issued by Annexure 4 in the favor of private respondent lordship. That's why we have filed this.
What is this? Changing the group number?
That's it. That is, they have themselves admitted. The respondent have themselves admitted that while uploading the tender lordship in EPROC site, there inadvertently group number was changed. That was not our fault. We accordingly submitted because earlier lordship in NIT, that is Annexure 1, your lordship, the description of work is renovation of guard room, approach road at SP Residence, Saharsa in the district of Saharsa. When the documents were uploaded, lordship, in the...
You are the L1?
Lord,
You are the L1?
L.
No, my lord,
Where is the comparative merit?
My lord, he has, my lord, suppressed the facts, my lord, and my lord, the writ petition has been filed, my lord, not with clean hands. My lord, the work, there are 2 work involved, my lord, in this case. Work number 5 and 6, my lord.
Show us from NIT.
Yes, my lord. Your lordship, can I turn to the writ petition, your lordship? Page 14, Annexure 1. Your lordship, at the bottom, your lordship will find there are 2 works, your lord, 5 and 6.
5 and 6?
Yes, my lord. Now, my lord, the work order has been issued, my lord, which has been challenged, your lordship, that is with respect to what work.
We are concerned with work number 5 and 6.
He is, my lord, concerned with this 5. He has applied for 5. Now, my lord, he is challenging the work order issued, my lord, in favor of the 6. My lord, establish it. And my lord, he has suppressed this fact.
No, he has not participated in work number 6.
No, not at all.
Then how can you challenge?
And Milord, second thing, Milord.
That is.
What is your locus? When you are not
Actually, that is I am trying to establish, Lordship. He himself has said, Lordship, may kindly see.
No, what is the reason? What is the reason? What is the reason for not participating in work number 6?
No, it was, I have participated. Description of work is there, Lordship. And it was inadvertently came in group number 5. It is their own submission, in their own counter affidavit, Lordship.
Both the jobs, Your Lordship, have been cancelled.
No, where is the classification of group number 1, 2, 3?
Lordship, it is e-tendering, Lordship.
Correct, sir. Where is it? How to understand? Item number 5 and 6 will fall under so and so group.
Lordship, their supplementary affidavit, counter affidavit, Lordship, in para.
Supplementary?
Their counter affidavit, Lordship. Respondent's counter affidavit.
No, Milord, he has stated that false affidavit. Milord, I will prove it in the court.
Let him submit. In the counter affidavit where?
Lordship, in para 3 sub para 5.
Sub para?
5, Lordship. 5. It is their own statement that, but at the time of tender uploading, I may be permitted, Lordship.
Yes.
But at the time of tender uploading, bill of quantity of group number 5 was inadvertently uploaded on the EPROC site in group number 6. And BOQ of group number 6 was uploaded in group number 5. But the description of work, Lordship,
Sir, how to identify which item will fall under group 5 and 6?
Annexure 1, Lordship, may kindly.
Annexure 1 to what?
It is rate petition, Lordship.
Where is the, now suppose take item number 5 and 6.
5, Lordship.
They are in which group?
Lordship, 5 is सहरसा जिला अंतर्गत पुलिस अधीक्षक के कार्यालय भवन परिसर के उद्यान का सौंदर्यीकरण एवं घेराबंदी.
I have supplied Milord the translated version, Your Lordship, may kindly see. Translated version, Your Lordship, I will find. Your Lordship, may kindly see. Translated version, Your Lordship. My rejoinder, Milord, replied to the rejoinder, Your Lord. I have Milord translated it.
What you have mentioned in the counter affidavit?
Yes.
Page 4.
Counter affidavit, Milord, contains categorical statement. In paragraph number, Your Lordship, may kindly see.
Page 4. The paragraph 5 or paragraph 3?
Your Lordship, I'm just referring to that. Your Lordship, may I return to paragraph 3, Your Lordship, then paragraph 3.
Yes.
And subparagraph number 1 thereof. And
no, in 5, what you have mentioned?
That at the time of tender uploading, bill of quantity of BOQ of group number 5 was inadvertently uploaded on the EPROC site in group number 6. And BOQ of group number 6 was uploaded in group number 5. And due to clerical mistake on the part of BOQ section, as a result thereof, in the bit details of the description of the work of group number 5 as contained in group, it was mentioned in group number 6. So, Milord, he has admittedly applied for group number 5. I will establish from the document, Milord, for which he had applied.
You are mentioning work of group 5 in group 6 and group 6 in group 5.
But Milord, there was no, Milord, any corrigenda published, Milord. No corrigenda was there. And Milord, Your Lordship, and see both the words, and Milord, both the words have been now cancelled by notification of Annexure 3.
Their Lordship, they have not cancelled the work.
Yes.
They have simply cancelled.
I have cancelled, Milord. I have my Annexure C.
No, if the mistake is committed by you, why he should suffer?
Your Lordship, actually, Your Lordship, I can try to understand what are the actually facts of Milord involved in this case. Milord, he was applied for group number 5. And for that, Your Lordship, I can allow.
Later on, you switch over the group number 5 to 6.
First, Milord, I will prove it that what is group number 5? What is group number 5, Your Lordship?
No, he has applied under group 5.
Yes.
Where is the comparative merit?
Your Lordship, the initial.
Where is the comparative merit? Whether we want to know whether easy L1 or not.
He is not L1, my Lord,
because the comparative merit.
6 was never, my Lord, 5 was.
Don't mix up. Now we are concerned with only group 5.
Yes.
Then group 5, easy lower.
Which was uploaded in EPROC site, Lordship.
Your Lordship, I can receive, my Lord.
Group 5.
My Lord, I have
Description
filed.
of work is there, Lordship.
Even if there is any mistake, group 5 or 6, rightly or wrongly, he has applied under group 5.
Yes.
In the group 5, easy L1 or not? In order to find out that where is the comparative.
Group number 5 was never opened, my Lord. My Lord,
why it was not opened?
It was opened, my Lord, of group number 6.
Huh? So what is the reason for not opening group number 5?
Submission, Lordship, on this part, Lordship.
My Lord, at least, my Lordship, I may be allowed to trace from the reports, my Lord. See what I brought on the report. Lordship,
No, what is the reason assigned by in the counter affidavit that you have not opened the group 5?
Group 5 was not decided. By that time,
correct, sir. What is the reason?
Subsequently, when you notice, my Lord, both the works, group number 5 and 6, they were cancelled. Now, my Lord, they did not. It's a part, my Lord. They are not the part of the, my Lord.
Where is the cancellation order?
Yes, Your Lordship, can you see?
That order
Annexure 2 I see page 12, my Lord, of my counter affidavit.
That order has been passed during the pendency of this.
Yes, it was pointed out, my Lord.
They were noticed.
And my Lord, it was
what is the reason assigned cancellation?
Nothing, Lordship. But
look, now, my Lord, this was for the campus of the SP, Lordship. The SP, my Lord, informed us.
Sir, what is the reason for cancellation? You are talking about SP office, that, this.
Yes.
What is the reason?
Yes, my Lord, because I have.
Sir, in page 12, have you assigned the reason? For this reason, we are cancelling.
Police, yes, my Lord, written, my Lord. पुलिस अधीक्षक सहरसा द्वारा बताई गई स्थलीय आवश्यकता के अनुरूप नए सिरे से मरम्मती कार्य का प्रकरण गठित कर इस कार्यालय में समर्पित करना सुनिश्चित करें और उसके पहले जो लिखा हुआ है उपयुक्त विषय प्रासंगिक पक्ष के आलोक में उच्चाधिकारी के आदेशानुसार निविदा सूचना 28 के ग्रुप नंबर 5 के लिए आमंत्रित निविदा ग्रुप नंबर 6 एवं निर्गत कार्य आवंटन आदेश को रद्द किया जाता है.
What is the reason?
Because below SP, where below the work was to be done at Sarsa, he is informed us, my Lord, the work has wrongly been mentioned, my Lord, in the work order. He has informed us.
Why SP
and
is concerned? At that time, why did
SP is the work of the SP. We are doing on his behalf. We are making, my Lord, we are police building construction corporation.
Where is this instance?
My Lord, we are, my Lord, executing agent, my Lord. We are executing agent.
There is no such assertion, Lordship, in this letter.
Order.
No reasons have been assigned.
Both cancelled, Lordship.
Correct, sir. Cancellation, all right. It is not supported by reason.
And, my Lord, again, my Lord.
How many times you want us to tell? No reasons are forthcoming. Merely some higher officer writes to cancel. You have gone to the. You have taken a decision to cancel.
Your Lordship, we are executing agency, Lordship. Our police building construction corporation is an executive agency, my Lord. He constructs police stations, quarters, other things, my Lord. Now, my Lord, the SP.
Sir, again you are going some beyond the this cancellation. Where are the reasons?
But, my Lord, reason is not there.
Therefore, your action is illegal.
And, my Lord, so far L1 is concerned, my Lord. L1, you are. Then, my Lord, your Lordship, can you look, my Lord, one document.
They have done annexed.
My Lord, one document, your Lordship, can you see, my Lord. If you enter, my Lord, I have filed. Your Lordship, can you turn to, my Lord, paragraph 3. And, my Lord, Roman 3.
How much EMD you have deposited?
Lordship.
EMD.
Yes, I was pointing out that, my Lord. I was just placing that.
EMD was, Lordship, its EMD was 34,100, Lordship.
34,100.
NIT, Lordship, Annexure 1, Lordship. And Annexure 2 is, Lordship, that the document that we uploaded.
All right, now they are cancelled. At the best, you are entitled to some compensation. That's all.
They have not cancelled the work, Lordship. They have cancelled work order. That is from their own document.
All right, it will be re-notified, no?
And Lordship may kindly see their
work order has been cancelled.
Annexure 2A is the work order, it is the bid detail of Lordship. It is that,
Sir, work order in favor of X person has been cancelled.
Lordship.
And now they have to re-notify.
But it has, Lordship, my submission is, Lordship, that during pendency of this writ application, they have cancelled it simply to frustrate my claim, Lordship.
All right, sir. That is the reason we want to award compensation in your favor, and also directing them to refund the EMD.
Lordship.
What is the worth of the contract?
Annexure 2, Lordship.
Lord,
Annexure 2.
Your Lordship, may kindly, Lord, bear with me, Lord. I have filed, Lord, the rejoinder reply, Your Lordship. Your Lordship, may kindly see that. Everything will be clear. He has filed the rejoinder to my counter affidavit, Lord, and I have filed reply there too. Now, Your Lordship, may kindly see that.
Sir, you have misled the bidders. Therefore, the petitioner is entitled to compensation.
You know, that, Your Lordship, order is not above all, Your Lordship. But, Your Lord, for my satisfaction, Your Lordship, may I place that.
What is that?
Your Lordship, I have categorically stated in paragraph number 3, Roman 3 below of the counter affidavit, that from perusal of Annexure 2 and 3 to this writ petition, it is manifest that petitioner is concerned with work number 5 of the NIT. And accordingly, he had submitted the tender documents with respect to the said work number 5. Pursuant to the e-tender notice number such and such, job number is not. Now, Your Lordship, may kindly see.
Now you have cancelled the.
He said, now, my Lord, he denies that. He said he had never applied for work number 5. I had applied for work number 6, my Lord. That is, my Lord, error. That is, my Lord, a blatant, my Lord, false statement, my Lord, given by him.
All right. According to the records, he has applied for item number 5, group yes. Number 5. Yes. We'll consider that only. But we are imposing.
And, my Lord, the order was, my Lord, passed, which has now no more existence, my Lord. That was work order was issued with regard to work number 6, my Lord. And, my Lord, that is no more in existence.
No work order has been in so far as item number 5. No work. Then what action you have taken?
Both the 10.
Correct, sir. How did you terminate group number 5?
That was cancelled, my Lord.
Where is
because of this confusion.
Where is that cancellation? The annexure 2.
And kept C of this.
R2C, annexure 2C.
Yes, sir. R2 is the below respondent number, R2 respondent number 2, C is below the annexure.
You have cancelled. That means group 5 you have cancelled.
Both below, group 5 and group 6.
5 and 6 you have cancelled.
So below, there is below categorical, below
yes,
direction. Direction there below.
The petitioner has prayed for the following relief. Short question for consideration is whether claim of the petitioner under group 5 is in order or not. Full stop. It is evident from para 3 Roman 5 of counter affidavit filed on behalf of respondent 2, in which they have specifically admitted insofar as assigning the group number subpara 5 of para 3 of the counter affidavit reads as under page 4. Further, during pendency of the present petition on 30th January 2023, respondent 2 has cancelled the group number 5 and 6 of NIT. NIT number 14, NIT number 28 or 28/2021-22. The second respondent has misdirected the petitioner in the result. During pendency of the present petition, proceeded to rectify in cancelling group number 5 and 6 on 30th January 2023. Therefore, the present petition do not survive for consideration for having misdirected the petitioner and compel him to approach this court, he is entitled to compensation and refund of EMD amount. Compensation is determined at rupees 50,000. The concerned respondent is hereby directed to pay compensation along with the EMD amount within a period of 2 months from the date of receipt of this order. Accordingly, the petition stands disposed of.
Lord, only one thing, Lord, I could not press your lordship. He has not admitted.
Huh?
He has admitted all this. Check, your lordship. He had that, the work number 5. Now, Lord is claiming for work number 6.
Should have rejected.
Serial number 27, Ajay Kumar Singh versus the State of Bihar for the petitioner's fee to pay their fee.
May please, your lordships. My lords, the issue in this matter is, my lords, pertaining to supplies for the district jails and sub jails. An advertisement was issued.
Supply of?
Some edible items and other miscellaneous items in jails, my lords, in the district jails and sub jails. The advertisement was issued. Thereafter, I participated. Technical bid was done, and then financial bid was also opened. That was on 30th of January 2023, financial bid. And then, my lords, thereafter, the rules of the game are being sought to be changed by issuing the impugned letter, that is Annexure 3 at page 29, by which it is said, earlier the rule was that for district jail, an item amount of rupees 40,000 and sub jail 30,000 for certain item, and for other smaller miscellaneous items for the district jails 10,000 and smaller items 5,000 would be deposited on a consolidated basis. But by the impugned notification, they say it will be 3.5%. 3.5% of what? That amount is not known, and that is what my lord had been pleased to consider and indicate in the first order that was passed on 17 February 23, and asking the respondents to file their counter in this matter. That when the amount is not known, how can you say that 3.5% of what? Now they plainly admit they are fair enough in their counter affidavit.
In the counter affidavit?
In paragraph 15, there are two sets of counter affidavit. My lord will kindly come to the counter affidavit of respondents 2 and 3. Yes. In para 15, they in fact admit at page 14 of the counter affidavit. That para 15, that the supply of articles in jails is not based on package system. For supply in a jail, a supplier can apply for supply of any item or a bunch of items in one category or more categories. So it is very difficult to ascertain the value of supply for the whole year of one. So on what basis they will be fixing 3.5%? And that too, my lords, after opening of the financial bill. The matter relates to only that, my lords.
Yes, Lord. So we have now we are taking at the rate of earlier financial year, Lord. So, however, the action taken was the view of Bihar financial.
For future tender, you take up this issue. Not for the current tender.
For the future tender, they can amend.
In certain jails,
you can't modify in between the NIT date and conclusion date.
In some district, it is still on, Lord. It has not been finalized, Lord.
It has not been
finalized, Lord. The process has not been finalized.
All right, in such matters you take. Now this has already processed and attained the opening of a financial bid was also open.
Yes, the financial bid was opened on 30 January and thereafter they are
Only with respect to the petitioner lordship. In other districts, it is still.
Question.
So State Council, we will simply say that Annexure 3 would not come in the way of the present tender process.
With respect to the petitioner lordship.
The petitioner has prayed for the following relief. On 17/2/2023, the following order was passed. The list of respondents have filed counter affidavit in para 15. Respondent 1 and 2.
2 and 3.
Filed counter affidavit in para 15. They have 2 and 3. They have stated as under para 15, page 14, extract. In the light of these facts and circumstances and the fact that impugned communication, impugned action of the respondent is dated 1/2/2023, whereas the financial bid has
been opened on 30 January 2023.
30 January 2023. Therefore, Annexure 3 dated 1/2/2023 is not applicable to such of those tender which have been floated prior to 1/2/2023, like the present case. In other words, for the present case, the respondent cannot invoke Annexure 3 dated 1/2/2023. With the above observation, the present petition stands disposed of.
Case number 28, Prathosh Kumar versus the State of Bihar for the petitioner Shri Vijay Kumar Chowbe.
The Lordship, just now I have received the counter affidavit, Lordship.
For filing rejoinder, if any, list this matter after 3 weeks.
Lordship. And your Lordship, in para 26, your Lordship, it has been stated that the work.
Are you ready to address the argument?
Work order has been given to the private respondent, your Lordship.
I am appealing.
Work order has been issued, your Lordship, to the private respondent. Lordship.
Then you have to include him.
Lordship, I have already notice has been issued, your Lordship.
All right. Now you want to file rejoinder or not? We have passed order. Why you want to make all those sufficient?
Case number 29, Mrs. Road Enterprises versus North Bihar Power Distribution Company Limited for the petitioner Shri Ashutosh Mehta.
My lords, on behalf of the petitioner. My lords, in this case, senior is appearing case in another court, my lords. He is coming. In this case, senior is appointed by.
All right. After few cases.
By.
Serial number 30 is withdrawn. Serial number 31, T2 Vertical versus the State of Bihar for the petitioner Shri Vijay Chowbe.
Order, I have filed supplementary affidavit, my lord, bringing the memo of appeal on record, my lord. And the state was directed to file counter affidavit on earlier occasion, my lord, they have not filed.
Who is for this? What happened to the appeal?
Lordship, in appeal, my lord, order has been passed, my lord, which is, my lord.
You are challenging the appellate authority's order?
Lordship.
My lord, arguing counsel is in another court, my lord. He has just
Arguing
requested.
counsel
Is in another court, my lord. He has just requested me to take adjournment for a day, my lord.
All right. After few cases.
Actually, your lordship, there is a part matter is going on. He will be busy in second half also. Therefore, now pass over for a day, my lord.
Pass over.
Serial number 32, Nilesh Kumar versus the State of Bihar for the petitioner Shri Akash Raj.
May I please, your Lordship? Because in this matter, there was an advertisement. I applied, Milos. It was for extensive renovation of a pond, Milos, at Block Hera. I applied.
Extension of?
extensive renovation of a pond mills at Block Khera at Jamui, district Jamui. This is Miller's page number 32, may kindly be seen, Miller's. I was declared as L1. I went to renovate the particular pond Miller's. The local people did not allow.
Work order?
This was.
They have entered into agreement?
Entered into agreement, Miller's. What had happened, Miller's, that.
Who has to provide land?
It was the respondent authorities.
Which respondent?
Miller's executive engineer as well as the circle officer. I'm just giving the respondent number, Miller's, to your lordship.
Number 3 and 4.
My lords.
I directed to file their counter affidavit as to why land has not been provided to the petitioner pursuant to the work order read with the agreement dated 11/11/2019, failing which adverse order would be passed.
Much obliged.
Notes that serial number 29, Ross. I'm so sorry, Notes. I was there.
All right,
Lord, your lordship had granted me 2 days' time to seek instruction from my client as to mainly on account, notwithstanding the fact that huge tonnage of non-degradable polycarbonates would be unleashed, whether he would wish to withdraw the petition to pursue it anywhere else. Lords, I have sought that instruction. My learned friend is also here. Lords, we will withdraw that. Yes. Because your lordships have said that this court in exercise of powers under Article 226 is not an expert, my lords, to decide without the. So your lordships may.
And counsel for this one, so seeks permission to withdraw this petition. Accordingly, petition stand dismissed as withdrawn. Such submission could have been made by the your colleague.
I know.
For this simple this thing, why he has brought you?
Lords, brought me, Lords. It's pleasure to be before your lordships, Lords, all occasions. Sorry, my lords are right.
इसका साहब सुनिए ना 32 में क्या हुआ सर? 32
May I permitted to mention one restoration?
Bench.
No, Lord. Restoration.
Solution of this bench. Combination of this bench.
Yes, ma'am.
Are you sure?
Are you able to understand? DV guided by both of us.
Yes, ma'am.
Try to get.
Yes, ma'am.
Serial number 1, Ashok Das versus the State of Bihar for the appellant Sri Shailendra Kumar Sahar.
My lord, the appellant could not be released on bail as he could not fulfill the terms and conditions of the.
So automatically dispose.
Yes.
And And Lordship, I have also called the report of the SSP Gaya, who has also sent the report mentioning that he has not been released.
Taken, learned counsel for the appellant on inspection submitted that the appellant could not be enlarged on bail pursuant to our previous order dated so and so, on the score that he could not fulfill one or the other conditions stipulated in the bail enlargement order. Accordingly, IAS so and so stands disposed of. You could not attend his daughter's marriage. Yes. They have already disposed. It's only for compliance. Not IA disposed, it's the compliance to the previous order.
Serial number 2, the State of Bihar versus Chandra Kumar for the petitioner Sri Madhukar Mishra.
Your Lordship, in this case, some defects are left. Your Lordship, so I permitted to 2 weeks time to remove the all defects, Your Lordship.
For removal of office defects, release this matter after 2 weeks.
Lordship, oblige it.
Right? Go.
Next witness को रख देते हैं.
मैम जो डेट देंगे फिर फ्राइडे आएगा, ये तो नॉर्मली बनता नहीं है इसको, फिर क्या करें इसको, फिर 10 में 120 हो जाएगा, 5 है 19 को फिर प्रेजेंटिव बनाएगा, देर हम लोग क्या है, हाँ बनाएगा ना, बनाएगा, हाँ सेकंड वाला 19 हाँ 20 नंबर में, पहला वाला तो कुछ नहीं, तो सिर्फ हाइएट ले आया था.
कितना सीरियल कॉल करेंगे?
20 नंबर. 20 नंबर.
20. उसके बाद
फिर नॉर्मल लिस्ट 33 से शुरू हो जाएगा. हम 20-2 के लिए जुडिशियल ऑर्डर्स हैं.
कौन वाला केस है?
लग रहा है कोई बड़ा केस है सर, 20-2 के लिए फिक्स होगा. हाँ उसमें लग रहा है कि
कमला की कंस्ट्रक्शन
हाँ कमला दीदी तुरंत लेकिन दिख नहीं रहा है।
अभी तो चल रहा है।
हाँ ठीक इसी में समझ लो इसी में
हम लोग का बहुत स्वागत है कि इसका यहाँ पर बड़ा बहस नहीं होता है। टेस्ट दे दीजिए इसको कहाँ शिकायत पे
साहब वाला ना साहब का देखिए कल वहाँ पर रखा हुआ है ना यही होगा इन्हीं से आता है यूज है यूज पलट के इसके ना कॉल करता है 5 का ठीक तो है
किसके
हम लोग के साथ का है हाँ
कौन है ये है
तो 2 वाला है ना कितना सीजन पे है वो
20
किसको बस These fees,
बाल गया था मुझे
Now the case fixed for 2:15 p.m. serial number 20 Kamaladitya Construction Private Limited versus the State of Bihar, Neeraj Kumar.
Lord, yesterday, Lordship wanted that whether this petitioner is eager to continue to execute the work, original work as per the agreement. I have contacted my client and the company representative is here also. They are ready to execute the work on the same terms and conditions of the original contract. Because the difficulty is that they have modified the total work without and they say original work you will execute only after executing the additional fresh. And
who respondent?
Yes, respondent. And 1 year will not, your lordship, admittedly there is document that 1 year, 3 months they foreclose the case.
No, all right, we'll ask them, are they ready to prepare
on the same terms?
Work on the same terms or not? If you want to deviate from that.
Their total deviation.
Yes.
And
we are ready to, my lord, if he is ready to, my lord, only that 3 to 35% of the all 9 works which are allotted to the.
Sir, you don't know whether 9 works for in terms of the agreement.
My lord.
They are prepared to work.
Group number 9 will not be here. Other case is under 2 arbitration and 2 are already extension they have granted.
Let him, my lord.
Only I request yesterday your lordship has said, taking that view that no extra, if it will permit in terms of the agreement.
No, whatever it may be, we don't want to tinker anything.
No,
say anything.
In terms of same agreement.
In terms of the agreement.
Agreement.
Take down. On 4/5/2023, the following order was passed. Today, and for the petitioner. On instruction submitted that the petitioner is prepared to execute the balance work in terms of agreement entered to stop.
The time schedule, I will.
That is what we are discussing. Your chief engineer is here. Where is your chief engineer?
My lord, engineer in chief, my lord.
आपको अब बाकी काम जो बचा हुआ है उसमें रीजनेबल टाइम आपके हिसाब से क्या होना चाहिए?
जो कॉन्ट्रैक्ट था 30 मंथ्स के लिए।
हाँ वो पता है,
वही 30 मंथ्स इनका चल, जितना दिन डिस्टर्ब रहा इसके वजह से, मतलब
नहीं जैसे आप कह रहे हैं 35% काम हो गया तो आप रेस्ट 65% के लिए प्रोपोर्शनेटली आप बता दीजिए कितना टाइम हो रहा है।
कर दिया जाए प्रोपोर्शनल।
2 years because it's a canal work. Now rainy season starts, there can't be work. During Rabi season and Kharif season, paddy cropping, again the canal work is not allowed. So that is the reason for long time taking.
1.5 years?
2 years, your lordship presently, because 2 seasons of the rainy season will intervene. From 15th June to 15th of November, the chief engineer.
Do you understand what he is saying? Is it correct?
Considering canal running period, it was decided 30 months. It was already considered in that canal will
1 year, 3 months I was allowed.
And rest period is available for work. And considering those 30 months was allowed. Actual working days is not 30 months. So considering such things.
No, sir, he is saying some season issue. Taking into that into consideration, why we should not allow him to complete the balance work within 2 years?
Initially, 2.5 years was.
Forget about initially and all. Now we have to see the present circumstances.
For 65% जो proportional time is required, that may be allowed.
1 year, 3 months they had allowed. Now remaining, even it comes to below 1 year, 9 months. I am requesting because 2 ready season will intervene 2 years.
From this 15th of June to
15 जून से प्रारंभ हुई थी उस समय भी काम that was in February. Initial contract was in February after the harvesting of paddy crop.
No, practical difficulty is there. That is the reason you are a better person. Being a chief engineer, we are asking you your opinion. Because of a season problem, water will be logged during which period?
Canal always runs in cyclic order. Every year it will done in Kharif, in Rabi.
Anyway, there is already a delay. Nothing will happen if 2 years is granted.
Okay, maybe granted.
What is that dictation, madam?
Learned counsel for the petitioner on instructions submitted that the petitioner is prepared to execute the valence work in terms of agreement in
A period of 2 years. A reason assigned for 2 years is that there would be a rainy season and certain difficulties would be faced by the contractor in executing the work. In this regard, we have oral discussion with the chief engineer, Mr. So and so, engineer in chief so and so. Accordingly, 2 years time is granted to complete and execute the balance work. In terms of earlier agreement with the above observation, writ petition stands disposed of.
That is not dated 26th of February 2015 because they had said
2 years will commence from 1st of June.
Only your lordship made mention that 26th, that original agreement dated 26th of February
Dated 23?
26th of February 2015.
Agreement dated 26th of February 2000.
On the same terms and conditions.
2 years from today, my lord.
Huh?
अभी तो हमको जाएंगे.
From today, my lord.
Not today. Can you ask him to go and work from today? Today half of the day is over. What is this?
After all, I have to establish my office, plant.
Don't bargain. See, from 2017,
machinery,
from 2017, if I am correct, we have already lost 5 years.
Only for fighting the cases in the courts, my lord, without working the on-site, my lord.
Don't make these comments.
Anyway, he has agreed for old rates. You must be happy.
My lord,
but state any comment I can bring on record in the public interest litigation how people are behaving.
Serial number 30. Serial number 33, Messrs. Olesh Mascon Private Limited versus the State of Bihar for the petitioners, Dr. Satendra Kumar Srivastava.
In terms of agreement, we go on. Agreement only.
Lordship, also on last occasion nobody appeared for petitioner.
Cancellation of agreement is after notice.
Your Lordship.
Where is that cancellation?
Your Lordship, he has admitted, petitioner also admitted a SOCO has been issued.
No, where is that order? Cancel.
I have not filed counter, Your Lordship, but I have not.
Where is that cancellation order?
Your Lordship, Annexure 5, page 45.
45.
Your Lordship.
What is the date of notice?
Your Lordship, two notice, 6/5/22 and 10/6/22. Second paragraph, Your Lordship, it has been mentioned.
No, where is the second notice? 6/5, 10/6.
10/6 and 6/5.
He has not submitted his reply.
Your Lordship, he has submitted Annexure 4, but he has not completed the work. He is seeking time till July 2022. I have also discussed in the office order, but he has not completed the work.
Why these notices for termination or for completion of work?
Your Lordship, earlier because the 2 and 3 years are.
Produce these notices.
Your Lordship.
Now find out whether is it for termination of contract or execute work within so and so date.
Your Lordship.
Counsel for the concerned respondent is hereby directed to file counter affidavit. The counter affidavit must contain documents like notice dated 6/5/2022 and 10/6/2022 in order to ascertain whether such a notice is related into termination of contract or asking to complete the completion of work.
However, it has been written for विखंडित करने के लिए for termination. However, it is written in the order that it is for termination.
Notice.
Your Lordship, it has been written in office order, Your Lordship.
All right.
कार्य विखंडित करने के लिए लिखा गया है, उसके लिए लिखा गया है।
उसके लिए कहा गया
करने के लिए नहीं लिखा गया।
पारा 2 में है वो।
My Lord will pardon me. That order of termination and the penal provision, which I had challenged, that has to be quashed.
Those orders are
impugned orders
are set aside.
That except P by 23 and P by 25.
So whatever the prayer, we will
online
after 3 weeks.
3 weeks.
Number 35 is adjourned for next week. Serial number 36. Serial number 34. Diksha Bharti versus the state of Bihar. Divakar Prasad Singh.
Lord, I have just received counter affidavit without
For filing
report manner.
rejoinder 2 weeks.
Serial number 35 is adjourned for next week. Serial number 36. Lakshagiri contract.
Because after execution of the agreement, the respondents noticed that their estimate was defective, and a committee was constituted, and they have reported that a comparative statement was prepared, and as per the revised requirement, there is 162% increase in the cost of work. Thereafter, my lords, the file is moving.
There are disputed issues.
No, but yes, it has been admitted, my lord. There is no dispute.
No, you are saying executable for the reasons solely attributable to the respondent.
Let the Annexure 4 I have annexed. If my lord is pleased to see Annexure 4. Annexure 4 and the letter of the chief engineer, he says that my estimate is defective. I can't do anything. Annexure 4, my lord, if my lord is pleased to see. Comparative statement.
What is required to be compared?
Yes. As per my lord's column, as per agreement, this was the cost. As per the revised statement, the last is, my lords will find at page 36. As per the estimate, it was 98 lakhs 90,000. Now, as per the revised estimate, it is 1 crore 68 lakhs. And now the
pagination.
Yes, the last this page.
Last.
And thereafter, there is a joint inspection by the superintending engineer, executive engineer. They say that ये कार्य करना उचित नहीं है, इस कारण प्राक्कलन को पुनरीक्षित करने. So therefore, the work is not advisable to be done, and there is a requirement of revision of the estimates. Until date, they are not revising, and they have started issuing so-called notices and debarment orders, notices and everything. If my lord is pleased to see Annexure 5, page 37.
Who has prepared this comparative?
Yes, this has been prepared at the instance of the Milord Superintending Engineer. Superintending Engineer, Executive Engineer, Assistant Engineer, Junior Engineer, everyone. The last page has. Thereafter, my lord's Annexure 5, page 37, if my lord is pleased to see, that is very conclusive document. I have not annexed any of my document, it is all their document.
It needs to be revised.
Thereafter, the engineer-in-chief also says that how it has to be done, it is pending till date.
Enter into agreement?
Yes, my lord, the agreement is, my lords, 15th of December 2020. It is page 26.
15th of December 2020.
Lordships, yes.
What was duration of agreement?
Yes, the agreement was to be completed on 14/9/2021.
14/9/2021.
Until date, they have not revised the agreement.
And in between, in July, they have revised the estimates.
They have, it is a proposal that to this extent, the estimate is required to be revised. They can't, it is to be done by the headquarters. The superintending engineer can only recommend lordship. It has to be taken by the headquarters.
It was just 2 months before your completion of the work.
Yes, and I have started writing that this can't be done, and the remaining 2 works I completed well within time, even before time.
You have produced NIT?
Yes, yes.
If the NIT have the reserved their right to revise the.
So there is also a public works account code. In that law, there is a procedure that if the deviation is up to 20%, then the chief engineer can do. If it exceeds 20%, then it has to come to the headquarters and it has to be approved by the cabinet. This is the procedure under the Bihar Public Works Account Code.
How your right is affected?
Yes, my right is affected because I had offered the rate on this price 19. Now
you are going to complete the work in the month of August 2021.
No, but they have noticed that the estimate itself is faulty. This work could not be done. This is what he's the chief.
No, you have already executed the work.
In the NIT there were 3 works. 2 I have executed. One, the problem is with 1.
No, why the third one was not executed by you before August 2021?
Because it could not be initiated because the very first they themselves noticed that their estimate is faulty.
Huh?
Their estimate is faulty.
On what point of time they have told? Only in the August 2021?
No, even before that, if my lord is pleased to see.
No, work order was issued in the month of August or July 2020.
No, the work order was issued.
No, work order was
15 December 2020. 12 2020.
20.
Lordships, yes.
You are required to complete within August 2021.
Lordships, yes. And immediately I write.
Now third work, why you are not executed?
This is what I write. Annexure 3, page 29 is my letter. That this work could not be because there is a defect. Notice that there is a defect. Within 2 months I reported to them. And on my report, they revised the estimate. That yes.
What was the defect?
The entire estimate, there was no provision for patchworks, GSB and WSB. So I immediately reported to them. Now they say that yes, we have committed a fault. Our estimate is faulty. The work could not be done as per this estimate. Very categorically he says, and within 2 months, Lordships, I have reported. The उपयुक्त विषय के संबंध में कहना है कि उप एकरारनामा पथ भीषण बाढ़ 2020 के कारण बहुत ज्यादा क्षतिग्रस्त है। एकरारित मात्रा में पथ की मरम्मती कार्य संभव नहीं है। इस मात्रा में इस कार्य को करना असंभव है। Within 2 months, Lords, I have reported to them.
And their concerned respondent is hereby directed to file counter chapter 4.
And debarment notice issued.
Huh?
Debarment notice issued.
All right, you file your reply.
Oblige.
Bill number 37, Messrs. S Enterprises versus the State of Bihar for the petitioner Sri Ranjit Kumar.
The counsel for the Lord respondent informed me that the NIT has been withdrawn.
So it has become
Therefore, it has been become
counsel for the petitioner on instruction of the pendency of the present petition. Subject matter of NIT is stated to have been withdrawn. Accordingly, the present petition stands as withdrawn.
Bill number 38, Anjali Enterprises versus the State of Bihar for the petitioner.
Lordship, the petitioner has annexed 2 documents. Both documents are not readable, Your Lordship. So a direction may be given to the petitioner to provide me that documents, Your Lordship, Annexure 3 and Annexure 6 of the writ petition.
Three typed copy is filed.
No, Your Lordship. Wherever we filed.
Typed copy is there. For you, it has not supplied.
But I am just giving the show cause notice.
Right.
One document is an admission by the petitioner.
And counsel for the petitioner is hereby directed to furnish one more set of writ petition. They are readable.
May I submit one thing? It's a blacklisting order. The show cause notice itself is readable. That is against the my lord's judgment.
And the admission which has been made by him.
Let him have the benefit.
After 2 weeks.
2 weeks.
Problem.
Bill number 39, Akash Kumar versus the State of Bihar for the petitioner Sri Ravindra Kumar.
This case, my lord, by the Annexure 8, the agreement has been cancelled and he has debarred from participating in any future tender, my lord. And then completion.
Where is the document dated 28/10/2022?
At page Annexure 8 at page 38, my lord. And it has been alleged that the work has not been completed in time. That is the reason for debarment of the petitioner from participating in future tender. My humble submission.
Statement.
Have you completed the work?
My lord, half of the work I have completed. I have annexed the bill also, but future part of the action, my lord, that there is encroachment and we cannot proceed with the work. We have informed to the authorities also, but neither the encroachment is being removed nor we are progressing with the work.
Without notice.
Lordship,
Page 38.
Specific so called has been issued.
Correct. Where is that specific?
In Annexure 4, my lord.
What is the date?
Date 18/3/22.
18?
18/3.
22.
22.
What is the date of his reply?
filed annexure 3 at page
Annexure 3 है.
Page date
5/8/2022, my lord.
5/8/2022.
22, my lord. And subsequent.
That is your reply. Sir, what is this? When the court is asking you something, you should point out, no?
I'm sorry.
Yes, sir.
My lord.
Where is his reply? Then why it is not reflected in Annexure A8, Annexure 8, stating that on date 18/3/2022 notice was issued. He has not submitted his reply.
Counter.
Total non-application of mine.
Time when we are to file the counter, my lord.
Why you want to take time? We'll set aside Annexure 8. We'll give you liberty.
Annexure 9, Lordship, that is representation of the petitioner before the municipal commissioner, Lordship. Annexure 9, page.
Annexure 9 is what? Is the representation or something? How is it relevant? It may be recent petition. Petitioner has prayed for the following relief. Petitioner has been debarred. The copy, order of debar dated 28/10/2022 reads as under page 38. The reliably learned that notice for debarring the petitioner was issued on 18/3/2022. Further, neither of the parties were aware as to whether the petitioner had submitted his reply to the notice dated 18/3/2022 or not. That apart, debarment order dated 28/10/2022 does not disclose about the issuance of show cause notice, whether petitioner had filed his reply or not. In other words, Annexure 8 debarment order dated 28/10/2022 is a breadth of reasons, a breadth of material and reasons. Accordingly, the petitioner has made out a case. Hence, Annexure 8 dated 28/10/2022 stands set aside. Writ petition allowed, reserving liberty to the concerned respondent to proceed in accordance with law, which of the concerned authority is hereby directed to take note of apex court decision in the case of UMC so and so, isolator so and so. Further action shall be taken within a period of 4 months from the date of receipt of this order.
Under the heading for hearing, under Rule 41, under Order 41, Rule 11, CPC, Serial number 40, Ramesh Kumar Option versus Hakikat Mari for the period significant Kumar.
There is chance of amicable settlement in the party.
Whether the matter was referred to mediation?
No, Your Lordship.
We will refer before the mediation, go and settle. Yes, respective parties are hereby directed to appear before mediation center on so and so date. Give after 15 days one date. Release this matter. On 21st June 2023. Mediator is hereby directed to make all endeavor settle the matter amicably with the consent of the respective parties, if any.
Under the heading for hearing, serial number 41, Tulsi Kumar Sahu versus Poonam Kumari for the appeal Srinagar SP.
Miscellaneous appeal against the refusal for
dissolution of marriage. My lord. But the petitioner was married to the respondent on 7th.
Read your ground number 2.
For that the impugned judgment is not in consonance with the provision of section 13 of the Hindu Marriage Act 1955.
Which portion?
My lord,
Merely you can't say 13. 13 consisting of
13.
so many.
13B, my lord, for cruelty, my lord.
13?
13B.
Not 13. 13B is for mutual. 13(1)(a).
13(1), yes, sir.
On the ground of mental illness, ma'am.
Huh?
Mental illness. On the ground.
Mental illness. Then there must be some other provision. You have not applied your mental. Without act you are appearing.
I am for the respondent.
Where is the Hindu Marriage Act? आपके पास नहीं है? ले लो.
13 in.
Don't have another copy.
Like only one copy.
What is this? Which clause, sir?
13A, ma'am.
13?
13A.
A. A is alternative relief in diverse proceedings. How is it read?
May kindly pass on this case, my lord, for Monday. Then I will.
Is 13(1)(a)(3).
Both the learned counsels are not prepared to address the argument. I release this matter next week. Read and come, sir. First of all, title itself is wrong. Which is there are 13(1)(a), so many things are there. One within bracket small a is relating to cruelty.
1A Roman 3 explanation 1.
Serial 42.
The trial court records are available. It's here.
Yes, ma'am.
Serial number 42. R.K. Roy versus the Union of India and others for the Christmas tree, Munda Prasad Dikshit.
In this case, Milan, at the very outset, Milan, I am referring the order.
Why CAT matters are always in the fag end of the list?
The hearing matter, that's why. I am referring the very order passed by Lordship on 4th April 2023. And the supplementary counter affidavit which has been filed is not the specific query put by your Lordship, Milan.
Yes, have you identified who is the competent authority?
Yes, ma'am.
Where?
Originally, he was appointed by senior personal officer.
We have already examined on number of occasions.
Yes, madam.
Now, question is who is the competent authority?
Competent authority, my lords, I have annexed the original Indian Railway Establishment Code.
That replies not to the council.
Rule 15.
She wanted to see who has approved the appointment of the petitioner. That is not there.
Your Lordship, we can now. The Annexure B series was referred, my Lord. Annexure B series of my supplementary counter affidavit dated 13 March 23, my Lord. There are two letters in Annexure B series. There are two letters dated 5/4/91. One is appointment letter and second is letter of posting. My learned friend.
Sir, in the letter of appointment, there is a reference. Competent authority has approved.
In the letter of appointment, there is no reference of competent.
Then where is that? Competent authority has approved.
This is Annexure B series at page 11, my lord. This is also order. This is also order dated, letter dated 5th April 91.
Annexure B series,
and at
page 22.
Yes, my lord.
It has been written in bold that this has the approval of the competent authority.
My lord, this is the letter of posting after appointment by Annexure B series first letter. There are two letters dated 5/4/91. First letter, and I have clearly explained it in my supplementary affidavit, my lord. Your lordship may kindly see para 3 of my supplementary affidavit dated 18/4/23.
Initially, the petitioner was appointed to the post of apprentice PWI. That is order dated 5/4/1991. After completion of the training, he was appointed on 21st September 92. 21st September 92, order is 141.
Sir, both the communication reflects that competent authority has approved.
No, my lord. No, my lord. The order
saying no, but we those documents are before us.
Your lordships may kindly see page 9, Annexure B series at page 9. This is the appointment letter.
No, this is provisional appointment.
Apprentice.
Apprentice means trainee.
Mila.
Where is the regular appointment to the post of way inspector?
141. Page 141. 21st September 1992. And your lordship
My
has gone through
lord,
that.
this is the appointment letter.
No, that is appointment, all right. Appointment to the post of way inspector, but he has been sent on apprenticeship.
My lord, that was the precondition to send someone on.
Then why have you mentioned in the assuming that in the joining report or joining communication as well as order of appointment that prior of this has been approved by competent authority. Who is the competent authority?
Actually, the competent authority, so far the reference of competent authority is concerned, in the letter dated 5th April, certainly this is the letter on after his acceptance as the...
Sir, who is the competent authority? Why did you write that?
My lord, I have explained it. I have explained it in...
Where you have explained?
I have clearly explained.
What is that later document here?
My lord, there are two. There are two.
That starts from page 163.
Your lordship may kindly.
Only they have
considered
include schedule.
There are two letters dated 5th April 91. One is appointment letter and second is letter of his posting under divisional engineer for training.
5th of April 91. In that you have mentioned this has approval of the competent authority. Who is competent authority?
My lord,
you better keep your officer present. Last time they were here.
Yeah.
There is no improvement.
My lord, your lordship may kindly consider this is page 9 is clear. This is the appointment letter and the letter is certainly dated 5th April 91. Both letters are dated 5th April 91. And in the letter of posting, it is written by the competent authority. Since after his acceptance of appointment, he was sent for training, and for this he was sent sent for training under Deputy Divisional Engineer, Danapur. Both letters are dated 5th April 91, my lords. My lords, I have clearly explained it in paragraph 3 of my second supplementary counter affidavit.
Page 9 is there?
Yes, my lords.
Page
9 of earlier supplementary affidavit, my lords.
Then which is the supplement further?
The further supplementary affidavit is which was filed on 18th April 2023.
13th April?
18th April 2023, my lords.
In that, what document you have produced?
My lord, your lordship may kindly hear me for a few minutes. The paragraph 3, that it is stated and submitted that there are two letters dated 5th April 1991 in annexure B series filed in supplementary affidavit, earlier filed supplementary affidavit. The first being the letter of appointment dated 5/4/1991 issued under the signature of Senior Personal Officer, Construction, Eastern Railway, Calcutta 1, a senior scale officer who was competent to issue the appointment letter to the initial appointment to the permanent way inspector, that is Group C post. The second being the office order number 31/91, Calcutta, dated 5th April 1991. This is also the letter dated 5th April 1991, which is the order of posting under Deputy Chief Engineer.
Inspector is Group C or D?
Group C, my lords.
Group C.
Yes, my lord. And for Group C, your lordship's direction, I have annexed the annexure E. Annexure E to this. Annexure E to this supplementary affidavit, second supplementary affidavit may kindly be seen.
Who is this? See.
Annexure E at page 9, the type copy may kindly be seen, my lords.
Where is Rule 215 IEC?
It is at
what is it? IREC.
Annexure E at page 9, my lords.
Huh?
Annexure E to this supplementary contract affidavit at page 9.
Sir, page 9, correct. Authority, you are referred to rule number 215 of IREC,
yes,
volume 185. Where is that?
It is here, my lord.
Here means what?
This is at page 9.
Page 9 only. It is typed copy. Authority, you have mentioned rule
just before it, my lords. Just above the typed copy, the whole.
Where is Rule 215?
Rule 215, or for convenience, the portion which is relevant to the relevant portion have been typed copy of the relevant portion has been given. This and then after this typed copy.
Sir, counsel.
Please read Rule 215, wherever it is.
Nature of power. Your lordship,
he is not having rule. The court wanted to see the rule. Where is the rule? You have quoted this.
The court is not available with me.
It is not available, means we withdraw this petition.
But authority is Rule 1-215 of Indian Railway Establishment Code, Volume 1, 1985 edition. This is the authority and nature of power, initial appointment of Group C and Group D post, headquarters, person for making appointment. Junior administrative grade and above, full in respect of all class 4 artisan and class 3 staff. Senior scale also.
You are not able to assist this court. We are repeatedly asking you.
My lord, I have been provided this the reference of Rule 15, which says that the appointment letter was.
Where is Rule 215? You are not reading Rule 215. You are reading from some chat. Can't you understand, being a senior counsel, whether is it Rule 215? Sir, being a senior counsel, you should be fair.
And I will permit it to.
You don't know how to read a rule. Is it a Rule 215? You are pointing out some chat. We are fed up with this case. How many times matter is listed? We have called the officer. Every time we will produce this, that matter is being adjourned from time to time. See, more than 25 pages.
This chart has already considered by Lordship in earlier writ application, Milord, stating that.
Sir, wait, sir. We want to know from them.
I am sorry.
Presently, from this chart only, I can show that as per rule.
Previous order dated 4/4/2023 has not been complied. Therefore, Mr. Saurav Mishra, Senior Divisional Engineer, within bracket coordination, EC Railway, Danapur, and Mr. Ashok Kumar, Senior Divisional Personnel Officer, IRPS, ECR, Danapur, are hereby directed to appear with the relevant records. The respondent counsels are not able to produce relevant orders or material information of the year 1991, the date on which the petitioner was appointed. In some of the communication, it is specifically stated that it has approval of the competent authority. The respondent counsel could not apprise this court who is the competent authority insofar as selection and appointment to the post of then Way Inspector post. The list after 2 weeks. Mr. Counsel, in chat you are referred to Rule 215 of some first edition 1985. Bring that book also. Again, we can't adjourn. You have to apply your mind. What are the requirements?
Rule 15 कोड ही लाना होगा
19/5